These two, yeah, we can't join. Okay, good. Check on these things. And then what we do is, Crystal, if she needs us our numbers or something to get our numbers. She's like, yeah. Oh, I see you. Is it there now? No. Huh? Oh, do you need the shot of the podium? Is the phone Wi-Fi or? No, wait, one thing at a time. Which camera do you have? Wait, the one looking at the judges or the one looking at the?
Well, right now, that one is pointing this.
You see that?
That one was fine.
All right, I'll put it back.
The one looking at the podium.
Okay, all right, so.
Dropping out.
Okay, so. Oh, it says preparing meeting. Just like.
Then you also want to say, like, get rid of the brief, but I think we're not.
And that's up to preparing both. So here, preparing meeting. I picked one that had auto save in there at the top. Ask her with the list. What was the last four?
Yeah, just somebody right now,
Daniel grab it. Just get it fresh. Oh, what's the, what's next?
Oh, I'm sorry, so the meeting ID is 974.
974. 572.
2911. Okay, first water, free water.
We have the whole condition restart. Which is right now.
Attorney Nathan Griffin.
Yes, ma'am.
So when you join the network, first you go to Google or something, get that term thing, get out or something.
So yeah, so using our mic off system, you'll be able to see it come up at the podium. Green light for your 15-minute argument, 2-minute yellow light reminder, and stuff, and you'll get your 1-minute road light reminder for your rebuttal. All right, and you guys want to go to
Thank you.
hopefully we'll get started right on time. I know they're trying to get a live stream and everything set up, so hopefully there won't be any issues.
Then why are we going on the Wi-Fi?
But if it's blocking
You want a bottle of water?
what is it blocking?
You know, it couldn't hurt. Jim, do you want water?
You want a bottle of water?
No, I don't.
Is the phone?
I mean, is there connections going on?
The phone.
Thank you, I appreciate it.
Yeah, no problem.
I have so many more days gallery, so they tell you as I go.
Oh, wait, phone first?
Yeah, just you can come to that.
Yeah.
Just Nash, they're over.
Okay, that's good, that's good. Okay, so now goes in.
I just wanted to get
Urban network.
Take the Wi-Fi back.
Saying that there's one exception.
Preparing meeting. We had it first Zoom meeting.
It was here and then it just dropped off.
Yeah, all of a sudden. But we're all here, look.
Just in case.
Oh, okay. Wait. We never got that before.
Oh, we didn't.
You're prepared, but.
Yeah.
This morning.
We couldn't get that stuff.
Yeah, these are this one, you know.
Okay, that's for other cameras. How's the view?
How's the podium view? Was it good? Good. Now, did you have it? We couldn't, we got it. You want to make Wi-Fi now? Yeah, because we couldn't get the, we couldn't get that, you know, the term sheet to come up. Here, I'm just, finally, yeah, the term sheet. I'm sorry, it wasn't a good My question here is, why are we using front-facing cameras? Can we be using a rear-facing camera, where it's a higher quality one in the back?
It's dark.
That's not what we use in our house.
I don't know.
It was dark yesterday.
So, I don't see the noise.
And they give you. No, we're doing. That one.
Although I have.
And I just asked, I asked what was the attorney fee.
You probably got him hanging up the ribbon down. What's the signal again?
You're having a good talk.
Oh, thank you.
Yeah, well, one else, yeah,
That's why you just like.
I don't know, he said he might. I don't care his son. Yeah,
Megan, there? I'm here. You're good? Yep.
Ladies and gentlemen, please rise. This Honorable Appellate Court of the 3rd Judicial District of the State of Illinois is now in session. The Honorable Mary M. McDade presiding.
Please be seated. May I call the case?
323-0272, Robert Stuckel and Scott Stuckel, appellees by David Smith versus Scott Rowe, appellant by James Griffin.
Mr. Griffin, you may proceed.
Thank you. May it please the court. My name is Jim Griffin here on behalf of the appellant, Scott Rowe. This appeal involves the Illinois securities law. It's a statutory remedy. Private parties can seek relief under this statute under certain limited circumstances, and they need to meet certain criteria in order to be entitled to relief. If that statutory remedy is not available, a plaintiff has common law remedies available. In this case, the plaintiff had 7 other remedies that were brought before the court and pursued besides relief under the Illinois security law. The foremost requirement to be entitled to relief under the Illinois security law is that the dispute has to involve a security. And in this case, it does not involve a security. And this was an issue that was argued from the beginning of the case through today, that the note at issue, which was appended to the plaintiff's complaint and first amended complaint, is not a security as that term is defined under Illinois securities law.
How about the maturity date, counsel, when project is completed or completion of project?
Well, that just determines when the loan repayment is due, but under the case law, the date of repayment is really not been the controlling factor on whether it's a security or not. It's what is the party holding the security entitled to receive. In this case, it's interest only. And you have the Boatman's Bank versus Durham case, Dvorkin versus Soderquist, Illinois appellate court cases. You have a number of Seventh Circuit cases, which Illinois courts have said are persuasive authority due to the similarities in the securities law between federal and state.
What about the motivation that his son would receive part of the property, part of the company, ultimate company?
Well, that's not what's pled in the complaint, and that's not what Mr. Stuckel testified to at trial. What was pled in the complaint, paragraph 110 of the First Amendment complaint, is that the note, that's the note attached to the complaint, is a security. It doesn't say the note plus other considerations, plus other facts outside of the terms of that note was a security. It says the note is a security. And at trial, what Mr. Stuckel testified to was entirely consistent with the terms of the note. He said, I was not making an investment in this company. I was not a partner. I was not a joint venture. I was not going to be entitled to repayment only if the company succeeded. He testified he was making a loan just like a bank. That was a question he answered. And that's entirely consistent with the terms of this promissory note, that the repayment was not contingent or dependent in any way on the success or failure of the borrower, AC1 Investments, not my client. And that is, under the case law, that is the key element. Are you entitled to profits?
Well, is there ever, I apologize.
Go ahead.
Is there ever a situation where the interest rate is so far afield from what a bank, for example, would charge that perhaps it is a function in part of profit? And I guess I'm focusing on the second, when they rolled over essentially when he wasn't paid the first time, if you understand my question.
Sure. Well, here the interest rate's 12%. So high, perhaps, from what you'd get on a bank loan.
I would like 12%.
But not, what's that?
I would like 12%.
12%, but I don't think we're talking usury terms here. It's 12%, and certainly not uncommon in, what I'd call a private loan arrangement. You're going to pay a higher rate typically than you would pay going to Chase Bank or First Third Bank. But in this case, again, there's nothing in the note itself that identifies this transaction as anything else but a straightforward lender-borrower relationship where the lender is getting interest at 12%. And
aren't there cases that say that more significant, that you can go beyond what the paperwork says? And didn't Mr. Rowe, in his video where he was promoting his the company, the plan for investing in real estate, say that, if using this property as an example, that Mr. Stuckel's son was to receive a part of the property?
But that's not, there are cases that they do say you look at the totality of the circumstances as to determination whether a instrument is a security. That is certainly true, Your Honor. But in this case, you also have to look at that video was never seen by Mr. Stuckel, so it certainly didn't serve the basis of his understanding of the transaction. And when you look at his testimony at trial, his testimony is, I was making a loan and expected to be repaid 12% interest regardless of any other circumstance. And that's consistent with the terms of the note, and that's consistent with how the plaintiffs pled and pursued this case. They sued AC1 for breach of contract seeking principal and interest, for repayment of the loan. So the plaintiffs did not plead anything except the note attached to the complaint being a security. And that was consistent with Mr. Stuckel's testimony. So here, I don't think there are any other, when you look at the totality of the circumstances, it's the note. It's what's attached to the complaint. That is the totality of the circumstances, because that's how plaintiffs pled the case, and that's how Mr. Stuckel testified.
Can you address the settlement agreement with AC1 and what, if any, relevance that has in terms of your client's ability to recover?
I think that settlement affects a few different arguments that we've raised. certainly, under the ISL, the only private remedy available is rescission. And once Mr. Stukel settled with AC1 and released all claims, and in that he represented that he had not previously assigned or transferred any of his rights under the promissory note, once that occurred, there could be no rescission, because essentially at that point that promissory note had terminated. Its legal existence was terminated due to the settlement. There was certainly no rights for any other party to obtain that note through some transfer and then pursue an action against AC1. That had been released. So that's one aspect of it. The other aspect that we've argued is the allegation here is that Mr. Rowe was acting as a salesperson for AC1. And the settlement agreement released all agents of AC1. And certainly, if Mr. Rowe was alleged, and that's how the matter was pursued, was alleged to have been, and if the jury believed he was a salesperson, then he fell within the scope of that release as being an agent of AC1.
Counsel, was that ever pled, and was a jury instruction ever tendered to that effect?
There was no jury instruction tendered to that effect. We did argue for that in our motion for directed verdict at the close of the plaintiff's presentation of its evidence.
No affirmative defense.
There was no affirmative defense. I guess our second main argument, besides the fact that the note is not a security, is that the requirements, the notice requirements under 815 ILCS 513B were not satisfied. That requires that a party seeking rescission of a security that had been purchased provide written notice to the party they're seeking rescission, and that's by registered or certified mail return receipt request. Now, in this case, again, Mr. Stukel admitted at trial that there was never any notice mailed out to Mr. Rowe or any other.
The lawsuit itself, though, would serve as notice, and it has been upheld to do so in other cases.
That's the argument of the plaintiffs, yes, and that was upheld in the Norville versus Alton Big Top restaurant, where that appellate court decision said the complaint in that case, under that circumstance, could act as a substitute for the sending of the notice. But the court noted in that case, in Norville, that the complaint itself contained the requirements of 513B. It stated that we are seeking rescission of this instrument, and that this has been brought within 6 months of learning that it was subject to being rescinded. In this particular case, the complaint, both the First Amendment complaint and the original complaint, do not contain any request for rescission, nor any similar terminology. Not only don't they use the magic word rescission, there's no other terms or language that are similar to rescission. And so we relied on the Endo versus Albertine case, which is a Northern District of Illinois decision, which involved the exact same circumstances as here, where the claimant under the ISL was claiming that the complaint was qualified as the notice under 513B, and relying on Norville. And the district court said, well, but your complaint in Endo didn't contain a request for rescission, nor any other language as required under 513B. And in that case, the court said, therefore, the complaint does not serve as a substitute for this written notice. And we believe the same holds true here.
Was that pled, and was there a jury instruction tendered with regards to the no notice?
There was nothing pled by the plaintiff regarding notice under 513B. As far as the jury instruction, there was no jury instruction tendered, though there was no dispute of fact relating to this notice. The plaintiff conceded no notice was sent out, and the only argument that the plaintiffs have made is that the complaint itself qualifies as a substitute for that, and certainly that's a legal determination for the court to make, whether the complaint itself satisfied 513B. The jury, it would not be within the province of the jury to review the complaint and determine whether a statute has been satisfied. And, let me add, there were, the plaintiff's response, at least the beginning of their brief, focused on failure to, make jury instructions on some of these issues we're raising. But I want to point out, the Illinois Supreme Court in Van Dyke versus White stated, the determination of whether a financial instrument falls within the definition of a security under the Act is a matter of statutory construction, which presents a question of law subject to de novo review. So whether an instrument falls within being a security is clearly a matter for the courts to decide, not the jury. In addition, there really are no disputed facts relating to this note. The note was pled. We've not disputed the existence of the note or its terms. Additionally, we're relying on Mr. Stuppel's testimony in our arguments. We're not contesting his testimony as to what his expectations were in making this loan. I think I've covered the substantive argument, either in response to your questions or the last argument we made was the attorney fee petition. There was an attorney fee petition that was awarded under the terms of the ISL. Of course, we believe that no cause of action should have been available here. But our argument was that under Bank of America versus WS Management, when a case involves some claims filed pursuant to statutes that allow attorney's fees and others that do not, the fee petition has to distinguish between time spent on those claims for which there is a statutory fee petition available and those which are not. And in this case, the fee petition did not do that. The fee petition covered all 8 counts against all 15 defendants.
But counsel, weren't the same facts involved in all of the counts?
Not in all of the counts, no. For example, the counts against Renatus that went to trial had to do with Renatus's control of Mr. Rowe. That was not a part of its claim against Mr. Rowe. It obviously didn't have to prove what Renatus's control was. So that's just one example. But there were others. The breach of contract against AC1. There are some facts that are similar, but not all together. There were certainly different legal theories involving different facts. So that's why I think the rule exists, which says you have to segregate these, so that when a court's determining what the fee award is, there's some fairness to a defendant that doesn't have to pay attorney's fees pursuing other claims based on other facts that are unrelated. Thank you.
Justice Hedl? Justice Palmer?
No.
Mr. Griffin, you'll have an opportunity in rebuttal. Thank you.
Thank you.
Mr. Smith.
May it please the court. Good morning, members of the panel. Good morning, counsel. My name is David Smith, and I represent Robert Stuppel, the plaintiff appellant in this case. Members of the panel, the jury in this case found the plaintiff proved every element upon which the jury was instructed. And that is extremely important in this case for a few different reasons. The record reflects that, prior to trial, the parties were ordered to appear before the trial judge with jury instructions ready. We did that. Jury instructions were exchanged prior to trial. Obviously, then the trial commenced, and we ultimately had a jury instruction conference at the end of trial, as is
Counsel, what kind of instructions were supposed to be tendered if the court would not accept the theory that this was not a security? To ignore the law?
Understood, Judge. And with respect to a jury instruction specifically with the question on whether this note is a security, I would rely upon, and I recognize that Van Dyke stands for the proposition that the question of whether a instrument is a security is a legal question. I recognize that. However, I would also point out that in Boatman's Bank and other cases, as I believe Justice Albrecht mentioned earlier, there is a required analysis of the facts surrounding the transaction. And in Boatman's Bank, for example, the court engaged in a detailed analysis of what happened, what were the understandings of the parties, what was the relationship between the parties. And so those are facts that a fact finder ultimately needs to review and determine.
Well, if I were just to look at Mr. Stuckel's testimony and then look at the promissory note, I'm having a hard time concluding that this is anything other than a traditional loan.
And I certainly recognize that. As I pointed out in the brief, Mr. Stuckel is an elderly at the time of the note was sold to him in his late 70s, close to 80, gentleman who was a retired carpenter. The only real estate transaction in which he had ever participated was the purchase of his house that he had lived in since the 60s. I would also point out that Mr. Stuckel did testify that he had a meeting with Mr. Rowe, and the video where Mr. Rowe describes in his own words how that discussion went was likewise put forth to the jury. Or in other words, and to the extent the members of the panel have not watched that video, I'd strongly urge you to do so. It's about 20 minutes. Mr. Rowe describes both how this transaction was supposed to go, what the relationships between the parties were, and he expressly states this is how the discussion went with the funds that Scott Stuckel, who's now deceased, brought, or in other words, Robert. And Mr. Rowe specifically states in that video that he explained to him that you're going to be investing this money. We're going to be purchasing a building for rehab. You know, all the things that I'm not going to repeat what's in the brief, but all of those things that we've pointed out. And the note on its face, and this is critical, states that it is due upon project completion. What project completion is not stated in the note. The way that we determine what project completion is by relying upon Mr. Rowe's statements as stated in the video that was provided to the jury. And I would likewise point out that on that note, the case of both Dvorkin, which was referenced by counsel, as well as U.S. Steel, stand for the proposition, and particularly U.S. Steel, which is cited in the brief, that's the Seventh Circuit case. But the Seventh Circuit specifically stated that when it determined that the noted issue in that case was not a security, first, there was a set maturity date, or what the court referred to as a short maturity date, which was 3 years. And the court in that case specifically stated payment of interest showed that it was not a security because neither repayment of the loan or the rate of return was in any way dependent on actual profits or success. Here, the note on its face states that it is due upon project completion. What is project completion? I'm sorry, go ahead.
But counsel, it doesn't in any way say that it's dependent on project completion or that there is any contingency associated with it. It's not dependent on the success of the project. In fact, Mr. Stuckel repeatedly testified that he repeatedly insisted that he needed a mortgage, and he kept asking for a mortgage. And a mortgage on the property, when you take out a mortgage on a property, you have put a lien on the property, and you expect that you will and the expectation is that you get back. There's no contingencies with the mortgage, and he was focused on getting a mortgage.
Well, and that is true. I would also put forth to the panel that whether a security is secured by something else, in this case a mortgage on the property, and whether it is in fact a security that contemplates success of the project, or in this case success of Simple Investment Systems and AC1, are two different things. Now, yes, Mr. Stuckel was under the impression that he was going to get a mortgage. Based on that impression, he believed that he was going to be secure, but the note and the project, as described by Mr. Rowe, contemplate that upon refi or sale, which that can only occur if the project is successful, the property is purchased, it's rehabbed, and ultimately sold or refied, the investors are then paid out. And as such, it required success of the project in order for payment to be dispersed.
Was Robert privy to that information, to the video?
Yes. Yes. And again, for my answer to that is based upon the fact that Again, Mr. Rowe, in the video, in his own words, says, this is how the discussion went with the money that was brought by Scott Stukel. Or in other words, Mr. Rowe says, this is what I said to Robert Stukel. And with respect to the instructions, candidly, in any jury trial, counsel has to make strategic decisions. Obviously, from a legal perspective, it is acceptable to say, well, we didn't commit fraud, but if we did, the notice was improper and things of that nature. In front of a jury, that's tough to do. Mr. Griffin, who candidly I like, we've developed a good relationship throughout this case, he made certain strategic decisions at this trial. The decision was made not to put in front of the jury, for example, whether the notice was sufficient. No instruction was tendered in that regard. The instruction that was tendered, the issues instruction in this case, that was tendered at the jury instruction conference, made no mention of any of these issues that are now raised in this appeal. The instruction which was proffered by Mr. Griffin at the jury instruction conference, which is in the record at C-4470, the only point raised in that instruction that was different than plaintiff's proposed instruction 17 was that Mr. Griffin argued that a finding of liability under the securities law was contingent upon a finding that Mr. Rowe was a salesman under the Act and an agent. Judge Barrett ultimately determined that that was not the case. However, most notably, the portions of that issues instruction that were not objected to which no alternative instruction was tendered, were, and I'll paraphrase here, that from your consideration, find that plaintiff has proven the foregoing. Plaintiff must also prove by a preponderance of the evidence the following: that Scott Rowe was not registered to sell securities, that he offered to sell the security, that he sold or offered to sell the security within the state which worked a fraud or tended to work a fraud, and that he employed a device or scheme to defraud, and that he obtained money through the failure or omission of material facts. Those were the issues that the jury was called upon to determine. So,
Counsel, when did Mr. Rowe receive any money in this transaction?
Well, candidly, Judge, that's something that we were trying to figure out throughout the entirety of the case. I can say to you that no direct evidence was presented that Mr. Rowe received any money from this transaction, other than, I would again point to the video that's in the record that indicates that Mr. Rowe was intimately involved in the transaction. His job specifically was to obtain funding. I believe he says in the video that he is the money guy. His joint ventures and private funding is his job. He's the person who goes out and gets the money for the project. So to answer your question, Your Honor, there was no evidence presented at trial directly to show that Mr. Rowe received or pocketed any of this money, but he certainly was involved in the sale of the security.
If Mr. Rowe is an agent of AC1, which seems to have been conceded at trial, then why doesn't that settlement and the releases in that settlement preclude recovery in this case?
Well, a few things on that, Your Honor. First, I would not say that his acting as an agent was conceded at trial. In fact,
well, are you disputing he was an agent for purposes of our discussion?
Well, Your Honor, to a certain extent, yes. I mean, he was ultimately the person who was in charge of obtaining funds for this project. I think that he certainly, under the statute, was a person who made a material misrepresentation.
Let me interrupt in the interest of time.
Understood.
Change my question. Assuming, for the sake of argument, that he was an agent, answer my question.
Yeah, understood. Well, a few things on that. First, as I mentioned in the brief, that was not pled as an affirmative defense. No instruction was tendered to the jury to that issue. And a party cannot fail to tender an instruction on something like that, simultaneously say the verdict was wrong. That's number one. Number two, I would also point out that the evidence in this case does show that a finder of fact could find that Mr. Rowe wasn't necessarily acting as an agent of AC1. Therefore, I think that the verdict is supported by the evidence that was presented at trial. So, one thing I did want to touch on, excuse me, was with respect to the sufficiency of the notice of the complaint. Mr. Griffin, in his argument and in his brief, has proffered to the court that, and requested the court to adopt the analysis that was undertaken by the federal district court in Endo versus Albertine. That case, frankly, obviously, in addition to the fact that it's not binding, was decided prior to Jacks versus Schneider Securities, which is a Seventh Circuit case that's also cited in the briefs as well. The reason why I bring that up is because, first and foremost, Norval versus Alton Big Top, while it references in the case that the complaint did have an express request for rescission in the complaint, it does not stand for the proposition that that is therefore a requirement. Or in other words, the court in Norville stated that the complaint, with sufficiently specific allegations, the complaint can serve as a notice. The court then noted in that particular case the complaint did specifically seek rescission. However, the Seventh Circuit in Jacks, the issue in Jacks was that an individual had tendered a handwritten note saying that I want my money back. And in essence, in Jacks, what the court did is they did not look at that and simply say, well, it doesn't seek rescission, therefore it's not sufficient. The court went into a detailed analysis stating that the request did not cite to Illinois law in any way, shape, or form, and it did not cite to the securities law. Here, the complaint did. The complaint specifically alleged securities fraud. It specifically cited to Section 13 of the Act. The only remedy available under Section 13 of the Act is rescission, and based on that, the complaint was sufficient notice. The only other thing that I would say with respect to this argument that the settlement agreement does not, or releases, or I apologize, that the settlement agreement therefore voids the issue of tender, which was also brought up in the briefs. So in other words, they argued that because we settled, we could not tender. I did want to touch on that briefly. I would also point out that that argument was not made in the court below. It was not made in their initial brief. And in any event, Section 13A2 of the Securities Act was added after the Toby case, which is cited by Mr. Rowe. And Section A2 specifically provides that if the party receives consideration for the security, then rather than tendering the security, quoting the purchaser no longer owns the securities, then they are entitled to the amount set forth in the rescission clause, less any amounts received. So with respect to the settlement at issue in this case, if anything, Mr. Rowe was entitled to, and I apologize, I see my time is up.
To finish this thought.
Thank you very much. Mr. Rowe is entitled to a credit potentially for the settlement received. However, again, given the paternalistic nature of the act, that's a proper reading. However, likewise, an instruction was not tendered on that point as well. Thank you.
Counsel, you had cited C-4470 as an issued instruction, but you also talked about a tendered instruction by the defense, or at least discussed. Do you have a cite for that?
I do. So plaintiff's tendered instruction is located at 4475. The tendered instruction by defendant is located at 4470, and the instruction actually given to the jury is located at 4425.
Thank you.
All right. Thank you, Mr. Smith.
Thank you.
Mr. Griffin, rebuttal.
Thank you. To address the arguments relating to jury instructions, the claims on appeal we're making here, none of them involve any issue of disputed fact. We are arguing what the terms of the note say based upon the face of the note itself, based upon Mr. Stuckel's own testimony and based upon what the interpretation of that is under Illinois law. So there's, to have made a jury instruction to the jury to make findings as to whether this note was a security would have been clearly improper. It's within the province of the court. And so no jury instruction would have been proper. Additionally, the claims, the arguments we've made relating to the sufficiency of the notice, the 13B notice, again, there's no disputed issues of fact. We did raise this in our motion for directed verdict at the close of the plaintiff's case, saying that the plaintiffs failed to show the required notice under the statute. And the circuit court denied that, but again, that was based upon undisputed facts. Mr. Stuckel's testimony that he did not send a notice out, he never sent any notice out, and our argument that the complaint itself, which would have to be reviewed by the court, not a jury, did not sufficiently qualify as a 513B notice. And let me add another matter with that 513B notice is it has to be done within 6 months of the party learning that they can rescind the transaction. And the courts have applied that. It's not a statute of limitation. It's a prerequisite to be able to obtain relief. And here, Mr. Stuckel never provided any evidence of when this 6-month period began running. So even if the court were to accept the complaint as a substitute for the notice, which we believe should not be, you then go backwards for 6 months and try to determine, well, was this a timely notice? And there's no evidence of when the plaintiff learned that the transaction could be voidable. So there's no way we believe there's no way the court could determine compliance with that requirement since there's no date. As far as there's question whether there was a jury instruction on the release that was argued. Here, what we've relied upon, and there also was no affirmative defense that Justice asked about, but we've relied upon, Keefe versus Greenwald, this is in our reply brief, where it says that once the defendant has established the release as a prima facie defense, or after admission by the opposing party. And here, the settlement agreement was entered into evidence at the trial, and it was admitted to by Mr. Stuckel that he entered into this agreement. We viewed that as an admission that settlement agreement had been entered into, and therefore there was no necessity for us to raise that as an affirmative defense. And based upon the fact that the plaintiff's theory, being Mr. Rowe was an agent of AC1, that release was sufficient to cover him. Thank you.
No question.
All right. The court thanks both sides for spirited arguments. We will take the matter under advisement and issue a decision in due course. Thank you very much. Court's adjourned until the next argument.
Thank you, John.
Ladies and gentlemen, stand to recess. I stay.
Is there garbage up here anymore? Can you sit here and
I can take that. Thank you very much. And you serve as a team in here.
Good job.
Thanks very much.
Oh, yeah, that's fine. You guys are but you need my whole spiel about the light box, everything. I was gonna say, I'm sure you're both fine, so do you have any questions? Okay, we can hopefully get started.
Oh, yeah, okay. I never remember. I'm not good. I do.
There's another question to answer.
I've done a couple of the remote ones, how it's ready to go, and
Right. Nothing about the actual case.
yeah, other than.
I'm fine.
It won't be there.
Yeah.
Okay. Worst case,
No, we're all here.
okay.
We're actually got it better now.
Better on my website. Oh, it's tape, I want to see the one.
I'd probably leave it.
Warm up? Okay. Well, I would never do a good job. I just want to get clear. Yeah. Fight from everything, right? I don't get any feeling.
Yeah, all of my arguments.
Sure.
Yeah, whenever time I look at that. Yeah. Like, yeah, no, they're like,
No, it's a weird atmosphere.
and so I was in about a week and I think
Good, still, but I didn't think you were doing other work or not.
then I got to start them all. Well, I think I would be right. Yeah. I don't know why.
Yeah, he was. No complaint there.
Ladies and gentlemen, please rise. This court is now in session.
Please be seated. Let me call the next case.
323-0331, the people of the state of Illinois, appellee by Justin Nicolosi versus Martez L. Moore, appellant by Ann Brenner.
Ms. Brenner, you may proceed.
Thank you, Your Honors. May it please the Court. My name is Ann Brenner. I'm with the Office of the State Appellate Defender here on behalf of the appellant, Mr. Martez Moore. Mr. Moore asserts that his counsel was ineffective in this case for failing to properly challenge the state's evidence that his blood alcohol content was .171 on the date of a fatal motor vehicle accident in which he was involved. This was the only evidence the state had to support the conviction for aggravated driving under the influence, death of another. Furthermore, the motion would have been granted under Illinois state law had it been filed.
Obviously, we're familiar with the facts, so let's just go to that.
Mm-hmm.
I presume you would agree that if Mr. Moore actually consented, there would be no basis for the motion and it wouldn't succeed. Would you agree with that basic principle? Not that it happened, but...
Absolutely, yes.
Okay,
if he had consented, it would be constitutional.
So what facts in the record do you rely upon to conclude he did not consent?
Well, the fact that the trooper warned him, gave him the warning to motorists, which is an Illinois State Police form. It's one of two forms, both of which comply with the statute, 625 ILCS 511-501. There are two sections of that statute which are commonly referred to as the implied consent statutes. And those are Section 501.1 and 501.6. 501.1 concerns driving under the influence, where a chemical test, a sample for chemical testing may be solicited by law enforcement only after they've established probable cause, which is evidenced by the issuance of a uniform traffic ticket, in that case for driving under the influence. So they've established probable cause of DUI. Under 501.6, on the other hand, the second of two implied consent statutes, that involves a fatal or type A injury, which is a very serious injury, motor vehicle accident, where the driver is found to have violated any non-equipment violation of the Illinois Vehicle Code. And again, just as in the first implied consent statute, probable cause must be established, and that's evidenced by the issuance of that ticket, the uniform traffic ticket. In this case, the warning was given, but a ticket was not issued, and Mr. Moore had not been arrested at the time of the warning. So do you have a question?
Well, this isn't a statutory summary suspension case, right? So
correct.
I mean, this is a question of whether there was a basis to suppress the blood result.
Correct.
What is it? Well, let me ask you this. How do we know which portion? It could be all. We have no shortage of cases where the officer, the trooper, screws it up and doesn't read the whole thing. I mean, do we have any idea what, assuming that it was the DUI warning to motorists that was read, because I think that was the testimony. Assuming that that's the one that was read, I mean, we have no idea which part of it was read, how much of it was read. We're just guessing in some respects.
That's correct, Justice Brennan. We don't know the specific details of what was read, when that warning was read. What we have is Trooper Quick's testimony that he issued the warning. When asked to describe the warning, his testimony was that it is the warning that we give to individuals we believe to be under the influence of alcohol or a drug at the time. He said he gave the warning, so it's implied that he gave the entire warning. But at the very outset of the warning, regardless, if he started to read the warning, the very first thing that he would have read was that you have been arrested for driving under the influence. And as a result of that arrest, which has to be based on probable cause, you have impliedly consented under Illinois state law to giving your blood or your urine for chemical testing. And then the warning follows up with a bit of a threat where if you consent to the testing and you're found and it comes back positive for either alcohol or drugs, you will automatically lose your license for a certain amount of time. But if you refuse the testing, having impliedly consented, you will lose your license for even a greater amount of time. I think it's a minimum of 1 to 3 years. 1 year if this is your first offense, 3 years if it's your second or third offense, and then going up from there. Those are the minimums. So our argument is that the consent was coerced because of that specific warning, because he was essentially threatened with the loss of his license for a greater period of time because he had impliedly consented by virtue of driving on Illinois roads, breaking the law, in this case being involved in a fatal motor vehicle accident. But when the warning was given, Trooper Quick did not actually have probable cause, and that would have been evidence if he did. It would be in the record, a uniform traffic ticket.
Does the warning to motorists actually use the language you have impliedly consented?
No, I don't believe that specifically.
That's an interpretation. I mean, that's our understanding of why we have it in the first place, but that's not in the warning to motorists.
Correct. It's not in the warnings to motorists. It's in the statutes, however, or it's at least in the case law that discusses the statutes.
Right. But again, we're talking about consent.
Right. So,
and you're saying that the warning to motorists somehow vitiated the consent. What otherwise would have been consent potentially.
Correct.
So what is it specifically that vitiates or makes any consent involuntary?
Well, it's the coercive measure of the threat that you will lose your license for a greater amount of time if you do not agree to give your sample because you have implicitly agreed to give it by virtue of driving on our roads and committing an offense, whether it's DUI or any non-equipment violation, and coupled with being involved in the fatal MVA.
At the time of the request of Mr. Moore to provide the blood sample, was there probable cause to arrest him for DUI?
There was not. There was not, because when Trooper Quick arrived on the scene of the two vehicle accidents, he first approached a white vehicle, which he identified the driver of as my client, Mr. Martez Moore, in court. Mr. Moore was unconscious. He was trapped in the driver's seat of the vehicle, and he had paramedics surrounding him trying to extricate him from the vehicle. So there was no contact between Trooper Quick and Mr. Moore on the scene of the accident.
Was there probable cause to issue a traffic ticket?
There was not, no. And in fact, that was specifically asked about on cross-examination, because the defense counsel did inquire as to why the other driver was ticketed and Mr. Moore was not. And so Trooper Quick was explicit that at the time that he issued the traffic ticket to the other driver for failing to yield to the stop sign, he had no knowledge of Mr. Moore's speed at the time of the crash.
When was the independent witness that talked about Mr. Moore's car passing his car at a high rate of speed, when was that discussion had with someone from law enforcement? Was it at the scene?
It was at the scene, but it would have been with different deputies.
Well, isn't there this collective knowledge doctrine, this idea that what's said to one officer is said to all officers for purposes of probable cause?
There's a potential for that, but that is not explicit from the record. And very clearly, Trooper Quick said that he gave the warning because he believed Mr. Moore to be under the influence of alcohol or drugs, not because he believed him to have been speeding at the time of the crash. And speed alone does not mean that you are under the influence, or quite a few people on our roads would be picking up DUIs.
And there's nothing in the record that would support the suggestion that Trooper Quick was aware of the hospital blood results at the time he read the warning to motorists. Is that correct?
No, correct. That is correct. The individual, the nurse who did the blood draw did not testify at trial. The parties agreed to stipulation that she did the blood draw in compliance with state law. But there's no indication, no, that it was a medical, that any party from the treatment team reached out to law enforcement and said, he's clearly inebriated.
And I want to just make sure I'm correct in this. I mean, we all know sitting here that there presumably was a hospital blood because they'd have to do one given his injuries, and we probably do have an alcohol number in that CBC or whatever, but there's absolutely no evidence of whatever that was in the record, correct?
Correct.
Right.
Correct. And just back to the point of the warning being coercive, I just want to refer you to an Illinois State Supreme Court, case, People v. Cazaza, which says where law enforcement falsely informs a citizen that they have the lawful authority to search and they in fact do not have that lawful authority, that search is unconstitutional. Again, that's Cazaza, C-A-S-A-Z-Z-A.
In People v. Harris, the wrong notice was read, and there was a suggestion that that was not coercive. Why might we not find that line of cases compelling?
Well, for our purposes, the difference between the two notices, the two warnings, it's a distinction without a difference, because both of them, at the very outset, state that you have either been arrested for driving under the influence or you are at fault for a fatal motor vehicle accident or a motor vehicle accident involving a type A injury, as evidenced by the issuance of a uniform traffic ticket. So regardless of which warning was given, the outcome for your analysis, as far as we are concerned, is the same. The state does point to Patel, which had a similar holding to Harris, but in that case, the facts were quite a bit distinguishable from our present case. The trooper in Patel did establish probable cause in that it was overheard. First of all, the driver rear-ended someone who was stopped at a stop sign, so it was clearly a red light, so it was clearly the driver's fault. The officer overheard the driver saying to the paramedic on the scene that he had something to drink as well as some kind of drug prior to driving that night. Then the officer went to his hospital bed, as did Trooper Quick here, but instead of just straight up giving him the warning, he initiated field sobriety tests, which defendant Patel failed. And then he gave him a breathalyzer, all of which are fine, all of which are legal without, that's the process of establishing probable cause. Those are all fine, but it's the line that Trooper Quick crossed, which is giving that warning that we are arguing is a coercive measure because it threatens the individual warned with the loss of their driver's license for a greater period of time should they refuse, because they have, under our law, impliedly consented by virtue of breaking the law. And that was not done in this case, because while the record, and I do understand your point, Justice Brennan, that the record is minimal and it's tough on a reviewing court when you're reviewing whether counsel was ineffective for not filing a motion to suppress, because the state didn't have an opportunity to respond to that in the court below. But here, the critical piece of evidence that would have been introduced is that uniform traffic ticket. And we can say quite clearly there was no traffic ticket written. So
one was written at some point, though, right?
Not to Mr. Moore, not by Trooper Quick, no. The actual investigation into the entire accident was done by two different individuals.
Ultimately, did Mr. Moore not receive some kind of a traffic ticket related to this case that was then dismissed?
No, not that appears in the record, no. He did receive 2 counts of aggravated.
I'm not referring to the DUI.
Yeah, no, there is no traffic ticket in the record.
Was there a traffic ticket, to your knowledge, ever issued?
Not to my knowledge, no. So just going back to the statute at issue, again, 625, 511, 501, we know that the traffic ticket is critical because our courts have singled out the traffic ticket as the component of the statute which makes 501.6 in particular constitutional. In 1992 case, King v. Ryan, the Illinois Supreme Court held that the prior version of 501.6 was unconstitutional because at that time, any driver involved in a fatal motor vehicle accident, I see my time is up, impliedly consented. And the legislature responded to that, finding that section of the statute was unconstitutional by amending the statute so that a uniform traffic ticket is required.
Justice Peterson?
I have no question.
No question.
Ms. Brenner, you'll have an opportunity in a rebuttal. Thank you.
Thank you.
Mr. Nicolosi.
Good morning, Your Honors. May it please the court, counsel, my name is Justin Nicolosi. I represent the state in this matter. As Your Honors discussed with Ms. Brenner, the state would submit that this is not an implied consent case. This is an actual consent case. And I would go even further. This is an actual consent case with an inadequate record. Justice Brennan, if you had asked me a lot of the questions that you would ask Ms. Brenner, I would have pointed to the stark inaccuracies, the inadequacies of this particular record with which to be able to answer a lot of these questions. This issue was not litigated below. Of course, counsel did not file the motion that the defendant is now wishing that counsel would have filed. Therefore, none of these issues were really flushed out below. We don't know
really many details about the conversation that Trooper Quick had with the defendant in the hospital. We don't know, of course, the specifics of the warning. All we have, of course, is Trooper Quick's testimony that the defendant agreed to provide a blood sample. That's all we have. The state would submit, based on this record, we would argue that that's sufficient to establish actual consent to as an exception from the warrant requirement, aside from probable cause. All we have is an officer asking a defendant a question, defendant saying yeah, and the blood sample having been taken.
How does the warning to motorists language and in coercive effect of the warning to motorists come into play with regards to tainting the consent?
Your Honor, as I did in my brief, Justice Brennan discussed Harris. In my brief, I discussed Patel. In Patel, a warning was given to the defendant who was also in the hospital. I believe the wrong warning was given there, but again, as Patel discussed and as Ms. Brenner discussed, the warnings are very, very similar. The court Patel found that the defendant who had agreed to a law enforcement request to provide a sample, that was consensual despite the giving of requests. That wasn't a specific topic the court in Patel focused on, but based on the record and the facts in the record and the decision, the state...
But as Ms. Brenner pointed out, in Patel, there's no question there was probable cause. In this case, do you agree with Ms. Brenner that at the time Quick had the discussion about consent, that there was no probable cause either for DUI or for a uniform traffic ticket?
Your Honor, certainly based on this record, I would agree with that. But again,
doesn't that distinguish Patel?
In a way, but again, the Patel did come around saying that they rejected the defendant's arguments about implied consent. They found that it was an actual consent case and that the defendant's consent was consensual, for lack of a better word. And again, the court Patel knew that the warning was also given there. I'm going to keep probably tethering my whole argument back to my first point that this record was inadequate. We don't have enough of a proper discussion because this was not litigated below, so we don't exactly know what happened. And I would point, as I did in my brief, the one thing I can point to that there is some evidence that there was probable cause is that Trooper Quick testified that he only gives the warning when he has reason to believe that somebody is under the influence of drugs or alcohol. And he did give the warning. So we don't know what other facts he had in his knowledge when he walked into that hospital room to give the warning and to talk to the defendant. But again, I point to the fact we just don't have enough on this record. We're really kind of grasping at straws here, kind of suggesting what might have happened, what Trooper knew when he knew it, all this kind of stuff. And the state would submit that collateral proceedings would be kind of a far better forum for this particular discussion.
When I look at the record, I'm not seeing the typical statutory summary suspension form filed with the clerk suggesting that law enforcement thought it should go forward with the statutory summary suspension, which might implicitly address this question of whether Trooper Quick actually thought he had probable cause. I mean, there was no statutory summary suspension in this case, correct?
I believe you're right. I don't know for sure, but...
And there could have been if there was probable cause and the warnings were properly read.
Yes. Again, you're right. And again, we're pointing to
things we don't know.
Things we don't know. I wish we knew more, but transitioning slightly to kind of the second part of my brief, that let's assume for the sake of argument that counsel was deficient for not filing this particular motion. Was defendant prejudiced? The state would argue the defendant was not prejudiced by the lack of the motion, and for that reason, I point to count 2 in this case. Defendant was actually convicted of 3 counts. First 2 were aggravated DUI. Third one was reckless homicide. But in my brief, I point to count 2, which was aggravated DUI for driving under the influence. Count 1 was, of course, blowing over .8, and that was the basis for the DUI finding there. But in count 2, blowing over .8 is not a prerequisite to finding guilt on count 2 as charged in 11-501.
But a fact finder might certainly consider 2 times the legal limit in trying to figure out, boy, I wonder if he was under the influence.
Sure, I understand, Your Honor, but the defendant on this appeal did not argue that the evidence in count 2 was insufficient. As I argued in my brief, there was sufficient evidence to support a rational trier of facts finding of driving under the influence based on his admission that he had 3 tall beers at about 9 a.m. I believe Trooper Quick was dispatched to the scene at about 10:50 a.m., so not a whole lot of time elapsed there. There was, of course, testimony about the modules and the vehicles, and defendant was going at a very, very high rate of speed, about 96 miles an hour, 5 seconds before the crash, was, as the prosecutor argued below, slow to brake. According to Brian Flonnery, who was the only eyewitness, the right lane was open. The defendant did not choose to swerve. The module also told the investigator that the defendant did not swerve. There are things in this record with which a jury could find that he was under the influence, regardless of whether that .08 or above number was provided. So the state submits that on multiple levels that this court should affirm this decision below and reject the defendant's claims. If there are any other questions, I'd be happy to answer them.
Thank you, Mr. Nicolosi. Ms. Brenner.
Thank you very much.
Could I just short circuit you a little bit?
Sure.
To turn a case name into a verb, why aren't you beached here? Why? How do we possibly have enough information to address the issues that you have fairly raised?
So a couple of things. Initially, it's the state's burden to prove that consent was voluntary. The case there is People v. Anthony. It's an Illinois Supreme Court case from 2001.
Well, that certainly is true in a motion to suppress, but this is a motion to suppress inside a ineffective assistance envelope.
Sure.
So it's a little bit more confusing in that regard.
Sure. We argue that it can be inferred from the record that Trooper Quick did not have probable cause, because if he did, he would have simply issued the uniform traffic ticket. It's clear from the warning that he was reading to himself, as much as he was reading it to Mr. Moore, that uniform traffic ticket was required just to give the warning, which is essentially, for lack of a better term, a threat to the recipient of the warning. One other thing as far as collateral review I would mention is that Mr. Moore received a 4-year sentence because it's an aggravated DUI. It's at 85%, and he is scheduled to be paroled in December of 2026. So we would also argue that in the interest of justice, that this be considered here on direct appeal rather than recycling the case and then brought back via a post-conviction petition. Pointing really quickly to People v. Eubanks, it's a Illinois Supreme Court case that was decided in the wake of the U.S. Supreme Court's case in Missouri v. McNeely, which dealt with exigent circumstances for chemical testing. And in that case, they noted critically that chemical testing may not be conducted incident to a DUI arrest the same way that a breath test can be. Instead, it requires either a warrant, which of course we don't have here, exigent circumstances, which we don't have here, because in Eubanks, the window of 3 hours was too long for law enforcement to have been concerned about the dissipation of alcohol in the blood. So certainly here, 4 hours, as counsel alluded to, between the accident and the blood draw doesn't amount to exigent circumstances. So of course, we're left with consent, which I know is what we've attempted to drill down to right at the outset, and thank you for that, Justice Brennan. I would just reiterate that under Strickland, the prejudice prong is that a reasonable probability exists that the trial outcome would have been different had the evidence been suppressed, and we are confident that that is true because without the BAC, he could not have been convicted of the count that he was convicted of, which is explicitly about 0.08 or higher. And then just quickly responding to a couple of things that counsel argued or mentioned. We do have from the record that Mr. Moore was drinking at 9 a.m. We don't know whether he finished his 3 tall beers at 9 a.m. or whether he was saying he had started his beers at 9 a.m. So we're not entirely clear of the actual time frame between the time he started and the time that the accident occurred. Again, I repeat that speed itself is not indicative of a DUI. And with respect to the argument that he did not swerve before impact, we know from the crash reconstruction expert that that Fred Becker stepped on the gas 100%, exactly 1 second prior to impact. Mr. Moore was already braking within half a second. That's much quicker than the average driver. It takes a second and a half. And of course, there was no opportunity to swerve. In fact, I think the reconstruction expert testified that there wouldn't have been any way to swerve. He hit the van right in the center of the passenger side. So the argument that his failure to swerve is indicative of his intoxication, I would argue fails here. And just in closing, I want to restate that we respectfully ask this court to find that Mr. Moore, his trial counsel, John Ridge, was ineffective for failing to move to suppress the blood alcohol content evidence prior to trial, and that the search of Mr. Moore's blood sample for evidence of alcohol consumption violated his constitutional rights under both the Fourth Amendment and Article 1, Section 6 of the Illinois Constitution. Thank you so much.
I have no questions. The court thanks both sides for a spirited argument. We will take the matter under advisement and issue a decision in due course. And the court's going to remain adjourned until the next argument. Thank you very much.
Ladies and gentlemen, court stands in recess as stated.
Thank you. This is my first one on Zoom. Yeah, I do all these mornings.
A lot more pressure. There's a lot more pressure. Yeah. Yeah, we get used to the Oh, very nice. Yeah, we had a lot of discussion about that. And I'm going to have to do this. Thank you, appreciate it. I was worried about that. Okay.
But we can make it earlier next year.
What kind of case is that? Is it a criminal case?
I think maybe it's something they get it to right. Okay, everyone, we got the attorneys that are here. They're going to see us in a moment to kind of inform us or we are pulled back to speak with the appellate justices. So I'm going to turn the seat. And we'll be back in just a moment. All right, where are you going to go to school? Iowa? That's not
I'm in Illinois. I'm also at Iowa.
Oh, cool. Yeah, you can start.
Indiana.
Oh, wow. I mean, USC. USC is that. Oh,
Okay.
It's not one of you there.
Yeah, she loves the next floor.
Very cool. Isn't it? Do you want any questions of the?
Well, the two arguments interesting at all, that you guys saw, that first one was really.
About the security law.
Yeah, I have a little bit more interesting.
We only knew about that security law because they talked to us like last week.
Okay.
We didn't know that was coming.
Yeah.
But, actually, I had a question for, specifically, I noticed that, I know you aren't seeing, we had a class, last semester, so we did appellate, arguments and brief, like, mock trial side, or mock appellate. But we were totally, and we're always only bring up things with the other party in section. So I was just wondering, why I didn't know this was because, right, I'm sure that works. Yeah, no, I noticed that you brought up other topics before you went into the rebuttal, so I was wondering why you were allowed to do that, and how that works.
Well, I mean, I think an argument could be made that everything I had said was a rebuttal to what was said in three, but it's been, you know, the rules and that I only limited what we argued. I guess, the thing was, I asked questions much earlier than I really anticipated. And so there was stuff that I wanted to look at, but I didn't say, so I wanted to get that in.
Yeah, the justices are usually pretty, at least in the third district, they're pretty lax on enforcing things like that. I'm not saying that it's in a negative or derogatory way. We're very grateful for putting up the flexibility in arguing.
I've come to school instructor, and they're like, oh, yeah, we want to get the school, but we get parameters, so.
Yeah, sure.
And these are different in the real world when they're on school.
Yeah, for sure, for sure.
Yeah, I think that's why.
I'm growing up friends.
Right.
But it's, responsible answer, it's not responsible.
Glad you didn't fit it, so I didn't have
No, I just came this morning.
Well, we have the justices here. We thought we were gonna go back, but they're here. And thank you, by the way. Thank you all for being here. You get your road trip here. Usually we go to you all in Ottawa, so, we're really thrilled to have you here and to open up discussions with us.
Absolutely.
What questions do you have for us?
I was wondering what your process is from here to make a decision after one time, from here to.
Well, we've read the briefs, we've looked at the record, we've researched it, we confer with one another, and we just had a conference back in the back about, you know, what we think and how we think we should do things. And then one of us will go back with our clerks and draft a proposed decision. And when we're drafting the proposed decision, we have basically three choices. We can write it as mostly, if the case comes to oral argument, it's not going to be a summary order. We can do a Rule 23, which are cases that are, you know, don't have a lot of precedential value, or we can do an opinion. An opinion, it has to be new, novel, different take on the law, and we propose the person who's writing up the draft, who's assigned to write up the draft, then submits it to the other two, and the other two chime in. I agree, I disagree. I think it would look better this way. I agree with you, but I think these changes might be helpful, or I dissent. Sometimes the other two disagree with the author on the ruling, and then one of them takes authorship. And then people decide whether they're going to write a dissent or a special concurrence. And then when all of that is done, we figured out who's doing what and who's on first. Sometimes we have a Zoom conference to talk about it. Sometimes we just pick up the phone and talk to, one another. And then we finalize it. And if it's going to be an opinion, we send it to the reporter of decisions for them to check to make sure it meets all the form and everything, and suggest changes, and then send it back to us, and we can accept or reject their changes if it's an opinion. If it's a Rule 23, we send it to the clerk files it, posts it, and we're done.
So you know that the panels are random, they're kind of assigned by the clerk's office, and the author is random. So that's something that we don't decide that after argument. We already know before argument who the author is going to be. The parties don't, but the judges do.
And there's also a process before we get to today. So when the case is assigned to one of us as an author, my practice and my group with my three clerks is I do an initial memo to myself after I've read everything, what my feelings are. But I don't share that with my clerks. I then have my clerks read it, and they do a memo, a short memo as to what they think and why. And if we disagree, then we have lunch and we talk a lot. But if we are on board, then I assign it to one of them to write. And then I write it with them and then review it, obviously. But it's a process. It really is. It's a question of reading it again, listening when the people that you work with say, hey, I disagree. And we just went through this not too long ago where two of us disagreed, and then the other author said, yeah, you know what? I didn't think of it that way. And that's the beauty of having three brains working on this instead of just a trial judge.
And, it's amazing because we each have three staff people. And in every office, all of the staff people proofread just to make sure everything, there's no errors, grammatical or typing or any kind of errors like that. It goes through the other justices, and they proofread everything. And then when we're done, sometimes you pick it up and you're like, oh, I missed that. But we've tried very hard. We're very careful about trying to make sure that we've dotted our I's and crossed our T's. And the thing that we as justices are most concerned about is that not only can a lawyer pick it up and understand what we're saying, but the litigants can as well. it's really important to us that what we write is readable by the public and understandable by the public.
Just one other thing, the cases are assigned to oral argument basically because people have asked to have oral argument. They put that on the bottom of their original brief. We do have the ability to say no. If we get a case and it seems like it doesn't present an issue that warrants oral argument, then we can decide that we're not going to hear it. So we contact the parties and let them know that it'll be decided on briefs in the judge's offices.
Justice McDade, I have a question for you. Have you seen a situation where the court asked for argument when the parties did not ask for argument? Because I've actually got one right now that I'm contemplating doing that.
I have, and I've also had a situation where we have had cases that have been assigned to research, which are normally cases that are just decided on the briefs, and they will decide, or the judge will decide that it requires oral argument or benefit from oral argument. And that's a nice opportunity for the people in the research department to actually be able to do an oral argument and be involved with the court.
Maybe Zach is our clerk could talk, I'm sorry, I got that look, that what? Being able to speak, yeah, just so that you can explain what research department is, okay?
So our great judge has at least 2 lawyers, if not 3 lawyers that work for them, they call them elbow clerks usually. The court also has right now 5 attorneys that work in a separate central staffing building, and they basically do the same work as a lot of the elbow clerks, which is review the cases, prepare draft decisions, confer with the judge, advise them on the case and the law, and then they'll write the draft a lot of times. Right now, those attorneys don't usually get cases scheduled for oral arguments, but as Justice McDade said, at times they do get called and asked to do those. And each judge will tell you they use their clerks differently. Some of their clerks will see it in oral arguments, some of them may never see it in oral arguments. Just how the judge wants it in their case.
I know there was another question, which was a couple of minutes.
So kind of sort of on the topic of just communicating with each other, obviously the different appellate circuits tend to split on some issues. So I was curious to what extent you guys communicate with the other circuits in trying to arrive at your own circuit decision.
Very little. With the exception that we do annually have an appellate conference where we do meet with the justices from the other districts in person. When we a lot of times what we will be discussing, or at least presenting, is differences on particular issues between the districts. I mean, obviously everyone is very thoughtful, and when they come to a different conclusion as to a particular issue, that's not willy-nilly, and they've already read the opinion of the people in the other districts. But we do discuss it, but we don't necessarily look for agreement. And this doesn't happen as much in the 3rd district, but if you go to the 1st district, where there are, I think, 24 appellate judges, I mean, you don't have uniformity in the 1st district on issues. You'll have different divisions of the 1st district disagreeing with each other. So it's the nature of the beast.
We're Cook County.
Right.
Yeah.
We're fortunate to have somebody that came from a different district. What was the second?
The second, yeah.
Little inside joke,
It only comes up like every day.
It was really helpful, though, particularly for me as, a young appellate court, a new appellate court judge, I should say, to hear a perspective from how things are done in a different district, because it is, and all this stuff is done differently in different places. The research department and the way that we handle it is handled differently in other districts also.
As an example, in the 2nd district, the justices work in groups for 6 weeks. 6 weeks. So the same 3 justices work together for 6 weeks. So that's totally different for us. We will be with, you can imagine the exponential possibilities with 7 justices.
Today,
exactly.
You're going to see all different, you've seen the 2 cases, you've seen different judges swap in and out, and you'll see completely different justices this afternoon. So we mix and match. We're having an interesting time, here because our district just changed with we were just redistricted. So we are no longer hearing cases from Peoria and Rock Island, and we're hearing now cases where we have DuPage County in our cases. And so it's a challenge because sometimes cases go up on appeal more than once. And so you sometimes can have a case where in a previous appeal in the second district, they ruled a certain way, which is different than the third district has traditionally ruled, for example, or different than you would like to rule. But may be different from what the third district has ruled. But the law of the case doctrine says you have to be consistent internally to that case. So you're stuck with what the second district has done, whether you agree with it or not. So that's an interesting challenge.
Other questions?
You have a question?
Yeah, this is mostly for the judges that are just on the panel, and features here, but open to anybody. What did you think that the attorneys did exceptionally well, or you agree with, and what do you think they could have improved on? As someone that's in school and learning about, and I want to be in the courtroom, so I guess, what are things that you've seen that are really good in the courtroom, or being good, like, or not so good?
They were to the point in this case. I think they both knew the issue. They knew what they had to focus on, and I happen to love that. Just when, all right, her whole name, we finished early, so that's
the attorney for the state, they made his argument, and when he was finished making his argument, he said, there are not any more questions, thank you very much. Which means just because you have the time sometimes doesn't mean you have to use it.
The other thing worth pointing out is that both sides made concessions when they should have. A lot of times lawyers don't want to make concessions that are potentially harmful, but they're much more credible when they acknowledge the things that they should acknowledge.
Most of them
both sides did that.
And most of them know when we ask that question, it's like a trick question.
And they were both very professional, no personal anything. No attributing motives, no aspersions.
So if you want to be in a courtroom, which you do, I know, whether it's on the trial level or the appellate level, pick your battles. Decide what hills you want to die on and the ones you don't. Because understand that judges talk. They talk to each other. And if you lose your credibility because you advance a position that is so ridiculous, people know. So pick your arguments. It doesn't mean that everyone isn't entitled to a position. I'm just saying, be able to back it up or don't take it.
The other thing, too, is if you were here for the first case, there were a lot of issues. And when you have that situation and you have a limited amount of time, I mean, no matter how many issues you have, there's usually only one or two that might be a winner for you. Obviously, that's what you're focusing on. Don't try to get through everything. It's never going to happen. Target your argument to what is going to be the most valuable.
Did you find the cases interesting this morning?
You got it too.
You mentioned having some initial feelings.
How
long do you find oral arguments persuade you aware of what values in oral arguments we already have initial feelings?
For me, I've been, I think, a validation more frequently than a change of opinion. The validation of something, an argument, would happen more frequently for me. There have been things that have come out in oral arguments that I questioned, and then I went back and I researched and felt like, okay, I was right for where I was headed before. But that is a good point in that when the argument is made, please make sure you're listening to the argument, because when you stand up to address it, it's always, for me, the very first thing that appellee says then is, let me just start with the last thing that they said. And suddenly you've got everybody thinking, okay, what is this? Because if it's that critical that you're flipping your entire argument to the very last thing, it's got to be important. So make sure you listen, especially during trials. Always listen, because that is how you learn.
I don't know how often it happens that we end up flipping a decision because of oral argument. But I think that the best chance that you have of having that happen is if you don't just stand there and regurgitate your brief. Have a story to tell us, something about your client, something that's not in the brief that could make a difference in how we look at the case. So it's really important, I think, for oral argument to do something other than what there is in your brief. And I think a lot of people really don't believe us when we say that we have read the brief before oral argument and that we really know what's in them.
The most important thing is tying the record to the brief, in my opinion. And that's something that if you spend a lot of time focusing on will help you obtain success.
The reason why argument is not typically, we all had a situation, it's rare, where argument has actually caused some thought and perhaps even changed the mind. But why it doesn't normally happen is everything should be in your briefs, right? There shouldn't be something new in argument. But I think all of us have used argument sometimes to ask questions where maybe it wasn't entirely clear in the record, or maybe it really was something you couldn't find. And sometimes the lawyer said, no, judge, actually, there is an answer. And that's where I think someone else mentioned earlier, knowing your record cold, even if you're not going to discuss it all, is important.
And don't assume the decision's been made either.
No.
Typically, the author has a decision. This is the way the case is going to go. Not always the case for the other panel members, certainly in my case. And on a rare occasion, as an author, I'm going in going, these are really tough and close issues. Let's hear what the lawyers have to say and let's hear what our colleagues have to say. That's very important. And we try to do that. Justice McDavid's been on the court longer than any of us, a lot longer than any of us. So, but I get the feeling that this newer group communicates with each other maybe more than in past years. Is that fair to say?
I think so. I think that when I first came on the court, most of the judges just worked in their offices and exchanged written documents, and there was not a lot of conversation. I really like conversation, and I tried it when I came on the court and got pretty severely rebuffed by some of these judges who did not want to be bothered. But I think that being able to pick up the phone is so much more effective than talking through text messages or emails, and you get that instant feedback. So I think that it's important to do the communication that we're getting now with the new judges.
And you've got a great meme, or whatever you call those things on your phone.
Justice McDade's time on the court has seen the evolution from written records where there was only one copy of the record that they had to ship to one another for the people to look at, and to electronic everything, and dial-up and phone calls.
Right.
Those paper records weren't that long ago either. 10 years ago, I think.
I'll tell you one thing that can't happen now with C-Track is there was a day when I opened the record and found a little packet of cocaine in it. And I did not know what to do with it. I called the clerk of the court and
I'm back.
We have a local rule.
There you go.
I know there's other questions, but I know we're in the pandemic and what's what was look on the last year. So we're going to need rather because we want to check back and get a photo. So if the justice is not now, we'll need to get a photo for our expert. No pressure, just so one gave one.
No, but when we're at lunch, you're going to be sitting there, we're going to be sitting there. If you have a question, walk over and answer it, okay?
You all not sitting and then we'll fill in behind you.
Okay.
We'll
be okay for the jury?
You guys make it back to the state.
Jury, so you all go to the back on the Thank you guys for coming.
Well, afternoon, I guess not. Good, how about you? I'm fine, thank you. Yes, please.
Oh.
No, you're fine. Yeah. I don't want to keep. Last thing you want is a hungry dog.
We need to move on to the. Oh, how are you?
That's good.
All right, I got everybody in. So
I feel like that's, yeah, the big thing.
ready? 1, 2, 3. Okay. Should you join?
Yeah, I'll put it down.
Gonna come back to you.
Got promoted.
Didn't have to go for the next one.
That's right. 1, 2, 3. Okay, we got 4. So.
Thank
Maybe you want to go down. Maybe I'll bring you.
So,
Well, they dive forward. Good work, John.
Yeah, well, I just undergraduate, and so, there's only an hour drive. Yeah. Okay.
Okay, we're gonna get our phone.
Need your phone? Anyone here from Illinois?
I know. No, I mean, I'm.
I coached out on Wall Street, Perkins, very cool. 30 years later, kind of.
30 years later, you got, 16 years later.
31.
That's my undergrad. Well, me, 6 years, well, this year, 6 years I've been in Champaign.
What are our instructions?
I think we follow.
You're gonna follow, yeah, somebody bring you right through that. You're USB into cover. Similar, he's in cafe.
Afternoon, beautiful,
No. Frankfurt, I'm from Ottawa, rural Ottawa. Well, we'll see you guys in lunch. All right.
Remember, both get one, so I'm not 100%. Go Bishop, go back. I just don't know the district here in the court. You got one job up there? Well, when you need, that one. Yeah, that's too funny, he doesn't lose each other. Oh, that's the woman's bar, that too, and he's actually on my social media.
Yeah. Like I shall be here.
You don't know all of the judges?
Are the lights automatic? Did they just turn on my phone?
What, Megan?
I said, are the lights automatic? I swear I just saw them.
They could be. We call Dave. Maybe that's what we're about. Back and forth. Hey, Dave, we need to start opening a corporate month.
Oh, these are not the Band-Aids I wanted.
I don't know if you can get a hold of Sergeant Eaton or one of their people to come online.
Maybe, because they do the master, right?
Okay, we're in the courtroom now because we went the back way, but the front door's locked. Okay, thanks, Dave. I'm gonna go back now.
How come I feel like I haven't been busy all last week when I was covering for people, and now I have so many emails?
Yeah.
Oh.
Rose is like driving me nuts today. She's like, hey, Mom, she's like, she's like, I'm sitting around and.
Who is?
Rose.
Oh,
Hey, this goes up and down. Look at this.
my neuro, I have a bunch of workers' comp stuff.
No. What? That's fancy.
They put that real low, give me noses.
No, put it up really, really high.
Lexington's nose is so like in your face.
I don't know, I think somebody might freak out.
That's funny.
That's Brian, right?
Yeah.
All right, Dave's supposed to be coming out,
Oh,
come out
thank
the
you.
door. I'm gonna back down before we do the judge.
Thank you.
Megan, do you have your sign-in for PM?
Yep, I got it over here.
Oh, okay. I came prepared, I have a little cooler, well, not cooler, lunchbox thing.
I wish that the secure access thing would work, because I just got a bunch
I
of
know.
workers' comp cards, and I was just gonna sit in my inbox and take up space. Just so you know, in the queue, there's an Anders motion and a motion to recall the mandate.
Oh, Jesus.
I'm guessing those are both for you.
Well, you know what?
They're gonna sit.
I can't do it today. It's gonna have to be tomorrow. Which we have tomorrow morning.
Yeah, it's kind of nice that we don't start until late.
I cannot believe none of those attorneys have responded to that email.
I know.
You got it, right?
Yeah, I got it.
Okay.
Who are all those? Are those all the attorneys? Because isn't there like a ridiculous amount of attorneys on the case?
There's like 26.
Yeah, that's right. But only two are arguing. Yeah.
2 are arguing for the appellee,
Yes.
and then 1 appellant. But the rest of them, yeah. But there's a lot of different parties
Yeah.
involved in all this.
Mhm. Oh, you're fine.
Um,
Some teachers are not going to be December, like, prior to our final, we take in March, and start on midterm. And we do August, so like, I'm doing August. I don't want to study for final, I don't want to study for final, and engineering, for the what they are calling. My first three stuff, I had writing, actually, I had 4 finals and teachers. So now I have 5 finals, so I agree 5 finals. I have like this information on them, but it's 5 finals and teachers. I don't know if that's next week. I'm taking a class. But I'm not taking the M3 now.
Ladies and gentlemen, please rise. This court is now in session.
please be seated? Would the clerk please call the next case?
323-0431, Menard Incorporated, a foreign corporation, appellee by W. Anthony Andrews versus the Illinois Farmers Insurance Company, appellant by Garrett Boehm Jr.
Thank you. Mr. Boehm? You may begin.
Good afternoon.
Good afternoon.
May it please the court, Garrett Boehm on behalf and counsel. Garrett Boehm on behalf of Illinois Farmers Insurance Corporation. The circuit court found that Farmers Insurance, pursuant to a text of an auto insurance policy, had a duty to defend Menards in a case filed by Patrick Cerrone, Farmers Insured, where Patrick Cerrone had filed suit against Menards after a Menards employee had run over his ankle with a forklift. This court should reverse the duty to defend determination by the circuit court for three reasons. The first reason is the application of the Eight Corners Rule. The Eight Corners Rule should begin any assessment of duty to defend under an insurance policy. Menards does not have an argument in contrast to the Eight Corners Rule, but instead argues waiver. Notably, the Eight Corners Rule was not ruled upon by the circuit court, but it should be ruled upon by this court. And the reason is that Eight Corners Rule is inextricably intertwined with and foundational to the main issue that's preserved on appeal, and that is the duty to defend.
Let me just ask a question. So, obviously, the Eight Corners Rule was not argued by you in the trial court, but even beyond that, I mean, you yourself relied upon extrinsic evidence, deposition testimony, et cetera, in support of your cross motion for summary judgment. So how do you come before us and then say we should not consider this extrinsic evidence and just rely on the Eight Corners Rule?
Well, the argument is that it was a mistake, that the Eight Corners Rule was not argued.
Why
it should have been argued.
The mistake?
Excuse me?
Why aren't you stuck with the mistake then?
Well, because I think that to maintain a sound body of law in the state of Illinois, that any duty to defend controversy has to begin with the Eight Corners Rule. And if the Eight Corners Rule is applied here...
So we're to ignore the extrinsic evidence and deposition testimony?
You only ignore it if it cannot be considered.
But you argued it and asked the court to consider it below.
It was argued, it was raised. I do not contest that at all. Simply arguing that this court, when it performed this de novo review, should begin with the Eight Corners Rule.
And continue on with what came in through the extra depositions and the like and everything that you raised. So don't be limited to the Eight Corners Rule, just then go on to include the extrinsic evidence.
Well, the extrinsic evidence could be considered and could have been considered by the circuit court if there was not any collateral estoppel impact of the consideration of that extrinsic evidence. Here, the extrinsic evidence was the deposition testimony of Patrick Cerrone, as well as 4 Menards employees that went to the circumstances of the accident and the damages to Patrick Cerrone at the Menard store. It went to Patrick Cerrone's understanding and view of his actions at the time before and at the time of the accident. It went to the employees, the Menards employees' views and testimony as to the actions before and at the time of the accident. Clearly, that all went to the merits of Cerrone's underlying tort action. So if, consequently, because it was that extrinsic evidence was critical to the underlying action, it really shouldn't be considered as an exception to the Eight Corners Rule. Now, if this court decides to consider the Eight Corners Rule and to consider the extrinsic evidence and move on to the question of whether or not there is a duty to defend, the only reasonable conclusion that can be reached is that Menards was not using Cerrone's truck at the time that Menards employee Juan Beltran ran over Patrick Cerrone's ankle with a forklift. There are 2 principal questions that have to be answered to reach whether or not there was a duty to defend. The first is whether or not Juan Beltran, Menards employee, was using let me take a step back. The first question is what use means under the farmer's insurance policy. The second question is whether or not there is extrinsic evidence indicating whether or not Menards was actually using the vehicle at the time of the accident. The farmer's policy would pay for damages, and this is out of the policy itself in the record, would pay for damages for which any insured person is liable because of bodily injury to any person arising out of the use of a private passenger car. The policy does not define use. Here, the term use should be given its ordinary meaning, and that's from the M.I. Holmes, Illinois Supreme Court decision in 2023. The ordinary meaning of use has been addressed by the Illinois Supreme Court previously in the Schultz case, Schultz versus Illinois Farmers Insurance. And specifically, the Illinois Supreme Court held that use indicates the putting to service of a thing. As to an automobile, the use of an automobile has been held to denote its employment for some purpose of the user. There is no extrinsic evidence. There is no evidence at all in this case that Juan Beltran employed Cerrone's vehicle for any purpose or put Cerrone's vehicle to any use.
Well, in Schultz, which you just referenced, it tells us essentially that use means, obviously it can mean transportation, it can mean operation, but use can also mean something beyond just operation and transportation. You agree with that?
Yes.
So if what I'm driving, what I'm using is a cargo van, it would seem to me the most logical thing beyond operating or transporting would be loading. Would that be fair?
There are certainly cases in the state of Illinois that have stated that use in an automobile policy would include loading and unloading. And the question here is whether or not at the time of the accident there was any loading that was occurring. The answer to that question is no, because Cerrone was there at Menards that day to pick up a special order of citing. That special order never left the racks of the Menards store. It was still there when the accident occurred. It was never touched by Juan Beltran. Juan Beltran was not even assigned to pick up that special order. Juan Beltran was not assigned to load Cerrone's van.
But the vehicle would not have been where it was, but for the instructions from the Menards to place the vehicle where it was to receive the load when it actually was be deposited on the top of the van, right?
Correct. When he came to the Menards store, they said, park it in this lot, go inside, speak to a Menards employee, they'll bring you back out and they'll get your citing and they'll put it on your vehicle. Well, it just so happened that they couldn't reach that citing because there was a pallet of cement blocks in the way. So Juan Beltran was tasked with moving that pallet of cement blocks. He moved it about 12 feet to the side, and in the interim, possibly Mr. Cerrone stepped forward a few feet, but when Mr. Beltran put the pallet of cement blocks down and backed up, he ran over Mr. Cerrone's ankle. And that is why we never got to a point where there was anything but a clearing of the path to that special order that was never loaded. There are two cases that I'd like to direct this court's attention to in particular. The first is a Supreme Court decision, and the second is an appellate court decision. The first is Estes Company of Bettendorf versus Employers Mutual. Now, this is an unloading case rather than a loading case.
Mr. Beam, let me stop you for just a minute. Any of the cases in Illinois that talk about loading as use, do those cases all involve insurance policies that had loading as an element in the policy?
So there are at least two cases where there's discussion of what use means but the complete operations doctrine was not endorsed or otherwise referenced, but there was a decision that use included loading. For instance, there's the Country Mutual Insurance versus Oler's Home case out of the 4th District in 2019. There's also the First Chicago Insurance versus My Personal Taxi and Livery. It's a 2019 case out of the 1st District. And I believe in Kim versus State Farm Mutual Auto Insurance, it's a 2014 case, the 1st District. They interpreted using, but it didn't involve loading.
But didn't the policies where they found that loading is using have loading included in the policy language?
Yes, typically, when it's a use policy, a maintenance, ownership, or use of the automobile, it will go on to state that including loading and unloading. And that's because if you go back in history over time, in the last 100 years, during the use of automobiles and insurance covering those automobiles, there's cases in other states indicating that loading and unloading is an extension of use. So that's why a lot of policies probably came to include the reference to including loading and unloading. Here, we don't have the loading and unloading, just the use.
But your position, if I understand it, is you're not contesting that use would include loading. You're saying that what caused the injury here wasn't loading.
It was not loading, that's correct. Okay. You've got it, Justice Brown, thank you.
So those acts necessary to load would not be included within your analysis, like the preparation.
I'm sorry, say that again?
Sorry. Those acts necessary to be able to load the product, such as preparing the vehicle, preparing the surrounding areas so that there was a clear path to load, those would not be included in your analysis. Loading would only be the physical act of loading, not preparing for the loading.
Loading would include picking up the object or product to be loaded, transporting it to the vehicle that was being loaded, and loading it on the vehicle. But actions before actually picking up that product that is to be loaded is not loading.
Moving the concrete out of the way.
Moving the concrete out of the way was not loading. Right. And how I get there is through the Estes case, for instance. In that case, there was cement that was being delivered to a construction site, and the cement was unloaded into a bucket. That was the end of the delivery process by the cement company. Then the cement in the bucket was moved by a construction site subcontractor with use of an overhead crane when the accident occurred. The Illinois Supreme Court said unloading has been completed when the deliverer has finished his handling of it. So applying that to the loading scenario, the conclusion would be that loading has not been initiated until the loader has begun handling the material to be loaded.
If we instead were to focus on the purpose, so if I'm unloading, the purpose is complete when I've unloaded the material to wherever I'm supposed to deliver it. But loading is a little different, isn't it? I mean, until it's loaded, until it's placed, in this case, on the top of the van, the loading's not complete yet. So steps taken to achieve that purpose, would it not be fair to characterize all of those steps as part of the loading process? I guess I'm trying to, I'm looking at the purpose rather than picking a point in time and just arbitrarily deciding when it does or doesn't constitute loading.
No, I understand, Justice Brennan. And there are cases, and Menards will argue that anything in preparation of loading should be included in loading. But the question is, are acts taken in preparation of loading still covered under use? And I would argue that the answer to that has to be no. And in particular, that goes to an Illinois appellate court case called Heath versus Bituminous Casualty. It's 36 Illinois Appellate Second 131, and I provide that site because I cited and referenced it with a caveat here today. I did not locate this case until yesterday. I did send it to opposing counsel, asked if he had any objection to my citing it. He didn't have an opportunity to respond, but I will be moving to supplement the authority in this case. It's a 4th District 1962 case. In that case, Heap was using a bulldozer, and he was using a bulldozer to move mats to a location where they were going to be loaded onto a truck. He was also clearing a path for the loading of those mats. Heap was not a loader. He was not assigned to be a loader. He was simply to move those mats from one location to another so they could be loaded. The injury occurred during Heap's use of the dozer. Now, the appellate court held that Heap was not engaged in loading. That clearing a path for loading was not a loading activity. Putting the mats into a place for loading by others, the loading was to be performed by others, was not a loading activity. Here, Juan Beltran was clearing a path, but he wasn't even touching the material to be loaded. He was working with ancillary materials. And so under Heap and under Estes, I contend that this court cannot find that Juan Beltran's act of moving that cement pallet was a loading activity that would be covered under the farmer's policy.
And he was finished with that, is that correct?
Yeah, he was finished with moving the pallet of cement blocks when he backed up his forklift and ran over Mr. Cerrone's ankle, yes.
So, to go back to a question Justice Davenport alluded to, a lot of the hypotheticals that you provide in your brief to kind of suggest the absurdity of extending the concept of loading too far from the vehicle, if you will. In this particular case, when I'm looking at what's happening in your argument, don't I have to take into consideration that it's happening in an area that Menard directed the vehicle to be in for purposes of loading? It's not as if it's in the home or somewhere else. I mean, it's in the loading, well, I'm going to just say the loading dock to make my point, but it's a little different, isn't it, than some of your hypotheticals?
Well, I guess, beyond those hypotheticals, I would guide the court back to Estes and Heap in saying that regardless of what I state in my hypotheticals, that those two cases should provide the guidance necessary for this court to find that the action of clearing a path and moving an ancillary product out of the way so that the product to be loaded can be loaded was outside what can be considered use of the vehicle.
The Heap case, did you say 1962?
1962, yes.
It's a vague recollection that cases that are more than 30 years old or 35 years old are non-precedent.
I believe it's maybe before 1945. I'm not sure about cases being more than 30 years old not being precedent.
I'll have to take a look at that. But can you give me that site again, please?
Yes, absolutely. 36 Illinois Appellate Second 131.
Thank you.
4th District. As Justice Brennan, as you were alluding to, Menards would expand. Oh, I'm sorry, I'm at the end of my time. I will step down for now and I'll have 5 minutes to rebuttal.
Yes.
Thank you.
Mr. Andrews?
Thank you.
Good afternoon.
Counsel. Good afternoon. If it pleases the court, my name is Tony Andrews, and I'm very proud to represent Menard Incorporated in this action. Today I want to address those very points that this panel raised. Extrinsic evidence versus Acorners, use, and we really didn't touch on causal connection. I'd like to touch on it if I can give and leave. If you don't mind, I'd like to briefly address the Heap case that counsel did send over late last night that I did read early this morning. And it is a 1962 case, which would be before Illinois accepted the completed operations doctrine. This might have been a different outcome if we were looking at current case law. But I'll also add that the connection in that case to the actual incident is so tenuous, it's beyond even the absurdity that Farmers proposes that we would suggest. In that case, Heap was employed by United, driving a United bulldozer on United property, moving product that Huggins, the injured party, who was employed by Keene, was going to put in a Keene truck after a Keene crane loaded it. So the bulldozer is about 4 steps away before the actual end, but by different parties altogether. So I'd ask Your Honors, when you review that case, if you do find any credence with it, recognize the a very loose connection, causal connection there. And of course, they did find it wasn't part of the loading policy, and that's also an employment injury to other issues. But that's my brief reference to Heap. If I might turn to the concerns the court raised on the 8 corners rule, beyond the fact that they waived it, and beyond the fact that they cited it in the trial court, and beyond they cited it here in these briefs, this court is allowed to rely on extrinsic evidence. I mean, we don't need a mistake. We don't need Judge Anderson doing the wrong thing. This court is allowed to rely on extrinsic evidence where it doesn't hamper the underlying plaintiff's action, where the issues before the declaratory action don't determine an issue that's crucial to the underlying case. Here,
Can I ask a question?
Yes.
Do you agree that if we did apply the 8 corners rule, that none of the facts in the underlying complaint would bring the case within the policy coverage?
Well, I would think that's an absurd position to take, and I've actually addressed that.
Well, I guess my first question is,
yes,
if we did apply the 8 corner
yes,
rule, would we be concluding that there wasn't coverage?
It's an excellent question. Then therefore, yes, the answer is yes.
Okay.
Then we would be beholden to wherever the choice of words were by Mr. Cerrone's counsel.
Well, I understand. I just wanted to know that that's where we would end up if that's where we.
Yes. If you don't look at extrinsic evidence, Mr. Cerrone's 2-page
Besides.
complaint.
What do you consider to be the words that were unfortunate, or the words you just used for the words of his attorney?
Mr. Bishop, an excellent lawyer, but a minimalist when it comes to words, only described in his complaint in literally 2 pages. His signature is on the 3rd page. Only he describes negligently operating a forklift, and the forklift operator struck the plaintiff. That's it, because that's all he needs. He's got 4 elements. Duty, breach of duty, causally cause. He did it. Did he need to address, by the way, my client had a cargo van, and by the way, unsolicited, and he was loading some 16-foot siding? Now, the interesting thing, Justice, and that's an excellent point, unlike Ruby Boland, who, as Justice McDade may recall, was the underlying plaintiff in Menard versus Country Preferred, 2013, we were just here 11 years ago on the very issue. Ruby Boland she tripped over some debris in the lumberyard, not quite the same area we're talking about here, but the lumberyard. Her lawyer, if it were Mr. Bishop's choice, could have pled, Menard, you have a duty to have no debris in your yard. Menard, 2, there was duty in your debris in your yard. 3, Ruby tripped over it. 4, she was causally injured. Boom, 2 pages done. I happened to get lucky. Under Farmer's analysis, Menard got lucky in the Boland case, which was underlying Menard versus Preferred Company, because her lawyer chose to go on for 6 pages. Didn't need to, but we're going to determine coverage based on the verbosity of, that's a new one, I looked that one up, verbosity of the original author of a tort plaintiff who has no issue with coverage. Fortunately, I mean, I was before Justice McDade 11 years ago because I didn't need extrinsic evidence, because that particular lawyer wrote 6 pages and literally, and described what he needed to describe. Dangerous condition, accumulation of debris, and an injury. Did that. But he went on for 2 pages, literally 2 pages, 7 times mentioning loading by a car. Loading car, loaded bricks in a car, vehicle, loading, 7 times. So we're going to determine coverage based on the choice that some lawyer who has nothing to do with coverage makes in his complaint. I would say that's an unsound basis to resolve coverage. Think about Tyler. Tyler is our gun case. The gentleman who was struck by a bullet by a guy who was unloading his gun. His lawyer could have written, you have a duty not to shoot me. You shot me. I'm injured, and it's your fault, and been done with it. What if we determined that case, Tyler, which is, a seminal case in this area, quite a while ago, based on just the minimum that the plaintiff lawyer could have put in his complaint? Or isn't it better? Isn't it more sound? Doesn't it make more sense? Isn't it more meaningful to include an analysis of the real facts, like we did here, like Judge Anderson did, and like counsel did? That makes a lot more sense and a lot more sound decisions. We're talking about making sound case law based on something that means something. That's what we should look at, extrinsic evidence. And by the way, let's not forget the point on this extrinsic evidence, why it's allowed, is the loading process. By the way, if this were the wall where the cantilevered shelves were and the 16-foot siding is, the van was directed to appear right there to the right of the load. The pallet was moved by a forklift that ran over the guest, Mr. Cerrone. If we were to recognize that what Judge Anderson did and decided to do had nothing to do with Mr. Cerrone's liability against Menard. Menard's liability was fixed in 2014, not 23 when they settled the case, not in 19 when Judge Anderson ruled, but in 2014 when a Menard team member, Mr. Beltran, ran over the plaintiff's ankle with a Menard forklift in a Menard yard with a guy who was instructed to be right there. Liability was fixed just because the forklift ran over him. Liability had nothing to do, in other words, Mr. Cerrone's action was not hampered in any way by the decisions that court, Judge Anderson, ruled on, the loading and the prepping for loading, nothing to do. In fact, Menard had to admit liability in that case and defend on damages because he ran over his ankle. Why else are we going to argue? Damages and damages only. So that's why extrinsic evidence is acceptable in this case, and for the reasons I mentioned before, why it's equitable to consider extrinsic evidence. If I may, my next point is use. Talk about use as an important issue in this case, of course. We all acknowledge that farmers chose not to define use in their policy. Could have, should have. They could have even stricken the word use, and it could have chosen the word operation of the motor vehicle. Didn't do that. Instead, they kept the router term of use as opposed to operation or driving. They could have used that word. Or they could have excluded loading. Could have done that. Didn't do that either. Instead, they just put use and leaves us to figure it out. Fortunately, our Supreme Court has done that. Defining use, as Your Honor pointed out, Justice pointed out, it's more than just transporting. It could be, or as Scholl said, I thought it was Scholl said, or to satisfy some other related need of a user. How much connection do we need other than some related use? And in this case, of course, a cargo van, loading cargo, surprise, and that's really goes to the causal connection, so I should drop that for the moment. But this notion that use is broader than just transport is a long-standing notion in this state, and more recently solidified in addition to this court repeating it and affirming it 11 years ago in Menard versus Country Preferred. Our first district did this in 19 in the first Chicago Insurance versus My Personal Taxi case, where they argued about coverage over, it was too far removed. But there's where the appellate court recognized that our Supreme Court in Scholl had not come out and specifically said use equals loading and unloading. But they said, we do. The appellate court in Illinois said, and they accepted a notion that they extracted from the Tennessee Supreme Court, which was pretty sound and also replicated by the Wisconsin jurisdiction, that use equals loading and unloading unless it's excluded. How hard is that to apply? Farmers doesn't like it, they just have to exclude it. They chose not to do that. So First Chicago stands for the proposition that use equals loading, period, unless it's excluded. That didn't happen here. Use is loading, and we all know about the complete operations doctrine. You guys are familiar with that. That's the modern view. That's the view that's supported by the weight of the jurisdictions. Going back to Toller. Toller said that in '84. This is old standing law. I mean, counsel wants to just turn. I don't know how many cases we have to flip to get the results he wants, to contort it. But we know that the complete operations doctrine is old, long-standing, affirmed many times by this panel, well, this court, and other appellate district courts. And we know that that includes, as Justice Brennan pointed out, includes preparation of loading. The entire process of moving an article, including preparation for loading. That is right out of this court's order in Menard versus Country Preferred in 2013. It includes the entire process of moving an article, including the act of preparation for loading. And then we can talk about all the iterations.
Andrews, excuse me. If the forklift driver had not been on site, but had been someplace else in the building, and in the process of going from wherever he was to go to the forklift to operate it, he had been injured, would that be covered?
Well, right. Would that be a preparation of loading is the question.
Yes, how far does that go?
Absolutely, it's a good question. Because it goes back to the time where he's fueling the vehicle, or he's unplugging it from the charging station and getting from here to there. Could be. I mean, frankly, a strict application of the entire process of moving an article, including preparation for loading, that this court utilized, could mean that. Now, fortunately, we're not asking to do that in this case. The plaintiff, Mr. Cerrone's vehicle is 20 feet from the object of his desire, the 16-foot siding. There's one, and what difference does it make? There's two forklifts here. I mean, one forklift could have done the same thing. They're just acting in tandem. What difference does that make? So we're not quite as far removed, Justice McDade, as that. I hear you. Do we need to stretch it? I'm not asking you to stretch it here. You could set some parameters if you so choose, but in this instance, we're not that far removed. We're moving the object so that we can remove the siding and put it on his truck. It's all within 20 feet of each other, if everyone's knowing what's going on, and there were two team members doing it. So this is the natural progression of loading, preparation for loading. I mean, I don't know where counsel wants to start it. Once we actually engage the thing, engage the product on the tines, but not as we're raising it, not as we're driving there, I don't know where you would then begin it either, to your point, Justice. But in this case, I'm not asking you to go too far. I'm asking you to go 10 feet, and right there. And in fact, it could have been one forklift, and it wasn't. But so I hope that, as my law professor used to say in tort, that was a good answer to some question. Was that a good answer to your question?
It was okay.
That was Professor Kiley at the ball.
Terrence.
Oh, yes.
It's site down.
And if I may address the causal connection piece in closing. We all know we don't need strict approximation. This court has made that clear. We know we need just some causal relation. This court has made that clear. We just need the reasonable contemplation. And back to Justice Brennan's point, farmers, the drafter of this policy, could reasonably contemplate that when they insured a 2006 white Chevrolet express cargo van with matching white roof rack that didn't have a seat behind the driver, no seating capacity behind the driver, no windows behind the driver, a pure, unadulterated cargo van. Farmers could clearly contemplate that that cargo van might receive some cargo someday, and it might be done by a forklift. So the causal connection here is very tight. And frankly, it's tighter than it was when I was here before, Your Honor, this panel 11 years ago. Ruby Bolin, again, Ruby Bolin, underlying plaintiff in Menard versus Country Preferred. Ruby Bolin tripped over some debris. Plastic, don't even know. The record didn't reflect what kind of debris. Yet the trial court and this court found that connection to tripping over debris had something to do with loading when there was no connection between the debris and the loading. Here, I'm actually prepping to load his product into Sharon's van. But in Bowen, we don't even know what the connection was between this debris over there and the loading of bricks, because she didn't get struck by a brick.
Would it be fair to suggest that the reasonable contemplation test might, in some sense, inform how far out you can go in terms of use, or would that not be a fair analysis?
You know, Justice, anytime you draw a line, someone's going to have to define where that line is or how dark that line was. Yes, might I be litigating that issue under that interpretation? Might you be doing it someday? Yes. Tough decisions are made based on tough calls. I mean, we can't.
I'm just asking theoretically, can you see the two working in tandem to, in another case, further out say, okay, that wasn't reasonably contemplated, but that would be used, or am I mixing two different concepts?
I think they could be bled together. I think they could be morphed, because in fact, as I drafted this argument, I saw them overwide, and in fact, they did it errantly here. They do kind of overlap each other. It's not unreasonable for this to be a use. It's not that unreasonable for it to be a causal connection. It is a reasonable contemplation test. Maybe we even condense it, make it a little easier, but I don't, unfortunately, I'm not asking you to go too far in this scenario, but I hear the concern. Yes, it could be drafted, maybe even more concisely.
Reasonable contemplation by whom?
Well, the carrier is the analysis. That in this case, farmers, when they insured the vehicle, could they reasonably contemplate, you know, if they were insuring a convertible or a sedan, could they reasonably contemplate that someone's going to put a pile of 16-foot plastic siding on a convertible? Maybe not. But could farmers reasonably contemplate that a cargo van will receive cargo? I think so.
Well, we're talking about the reasonable contemplation of the insurance company,
yes,
but we're judging it on the reasonable contemplation of lawyers and judges who are accustomed to drawing out lines and making connections where they didn't previously exist. If we look at the reasonable contemplation of the insurance company, I think that we may be looking at something different than what we're looking at, what you're asking us to look at here.
Well, what I can offer you, Justice McDade, is that this court did a fine job the last time when we were here in 2013, and how many disputes have we had over this since? I think you did a fine job, and I think it can be done without perverting any any justice on his head. So,
well, I appreciate your saying that, but I think there is a limit.
Yeah. Well, fortunately, we're not here in this case, but I see the prospect of the future, and I hear the concern. I'd be happy to help you draft the opinion if you are so inclined. Thank you. I see I'm my time. Any other questions? Okay. Thank you.
Thank you. Mr. Beam, rebuttal.
That's all right. Gotcha.
I'll try to be brief. A couple of points raised by Tony. It seems like he was arguing that this court should, in essence, revise the Eight Corners rule or abandon it because of the whims of the drafter of the Cerrone lawsuit. And I would say that if the Eight Corners rule is applied in this case, it would be unfortunate to Tony and his client, but that's what the Eight Corners rule is. That's how it's been adopted by the Illinois Supreme Court. And if this court applies it, it should apply it as Illinois Supreme Court said it should be applied. He indicated that farmers didn't have to use use in its policy, but the reason use was used in the policy comes right out of statute. And that statute is the motor vehicle liability policy defined as 625 ILCS 5/7-317 cited in our brief, and it addresses what an owner's policy is and what it includes, and that includes the maintenance, use, or operation of any motor vehicle. So that's why that text is incorporated in the farmer's policy. He also suggested that what is included in the preparation of loading, in essence, should be open-ended. And I just don't think that that is supported by any of the case law. If you look at any of the cases that have applied what loading or unloading is, all of those cases in the state of Illinois involve dealing with the material or person that is being loaded or unloaded. None of those cases involve manipulating another material or product in order to get to the product that is going to be loaded. So this would be an expansion of the complete operations doctrine, and I suggest to this court that it should not be so expanded. As to the reasonable contemplation test and the causal connection issue, the two cases that have been discussed most prominently are Menard versus Country Preferred and Country Mutual Insurance versus Ohlers Home Care. But both of those cases are very distinguishable upon the facts. In Menard versus Country Preferred, a Menard's employee was helping a customer load bricks into her car. During that process, she was injured when she fell over some debris. Here, however, there was no vehicular conduct involved. And when I say vehicular conduct, I mean conduct involving Cerrone's vehicle. Cerrone's vehicle was not being moved or loaded or used or anything at the time of the accident. In Country Mutual Insurance versus Ohlers Home, the defendants were loading Jeffrey Ohler into a van. He was a quadriplegic in a wheelchair. He was getting into his van after a visit to Sam's Club, and he was about to be put into the captain's chair in the specialized van. He fell out of the wheelchair, broke his neck, and ultimately died. But there was a normal, the placing of the disabled person into that van was a normal and reasonable consequence of the use of the vehicle. But Mr. Beltran's movement of the pallet of cement blocks, I don't think you can reach the same conclusion that that was a normal and reasonable consequence of the use of Cerrone's vehicle. It was not reasonably contemplated by farmers or Cerrone that Beltran's conduct of moving that cement pallet of blocks and backing up over Cerrone's ankle was a risk that was reasonably contemplated by the parties. And because it wasn't a risk that was reasonably contemplated by the parties, there isn't that causal connection. And for that third reason, this court should reverse the circuit court's determination of a duty to defend Menards in the Cerrone lawsuit and find in favor of Farmers Insurance. If there's no other questions, thank you very much.
Okay, thank you.
Thank you, Your Honor.
We thank both of you for your argument this afternoon. We'll take the matter under advisement and we'll issue a written decision as quickly as possible. The court will now stand in brief recess for a panel change.
Ladies and gentlemen, court stands in recess as stated.
Sorry, I dropped my phone.
Not why you're doing excellent, or you sort of good. How are you?
Ladies and gentlemen, please rise. This court is now in session.
Please be seated. Thank you. Will the clerk please call the next case?
323-0137, the people of the state of Illinois, appellee by Adam Trejo versus Jordan Henry, appellant by Emily Brandon.
Ms. Brandon, you may proceed.
Good afternoon, Your Honors, and may it please the Court. My name is Emily Brandon, and I'm an Assistant Appellate Defender with the State Appellate Defender's Office, representing Jordan Henry in this matter. While there are two issues raised in our brief, I'm going to be focusing my argument today on the first issue regarding Will County being the improper venue in which to try crimes which were committed entirely in Cook County. However, before I get into my argument, I want to give a brief recitation of the facts. On February 23rd, 2022, Torrey Kosich was sitting in his car in the parking lot of a 7-Eleven in Chicago when Jordan Henry approached him and ordered him out of his car, allegedly at gunpoint. Mr. Kosich immediately complied, walking to a nearby mattress store where he called the police. Mr. Henry thereafter left the 7-Eleven in his own car, but with Mr. Kosich's cell phone, which Kosich had left behind when he was ordered out of the car. About 30 minutes after the incident with Kosich, and still in the city of Chicago, Mr. Henry approached Uber driver Gollum Scott, who was parked and waiting for a customer. Henry ordered Mr. Scott out of the car, again allegedly at gunpoint, and Mr. Scott complied, and Mr. Henry drove off with Mr. Scott's Volkswagen Jetta. About an hour after the incident with Mr. Scott, an Illinois State Police trooper spotted the stolen Jetta traveling southbound on I-94 in Chicago. The police chased the Jetta through the Chicago area expressway system until the Jetta crashed along I-55 in Will County. Mr. Henry fled from the crashed Jetta and was quickly apprehended. The cell phone that Mr. Henry took from Torrey Kosich was later found in the Jetta. And although it was alleged that Mr. Henry used a gun to force Kosich and Scott out of their cars, no gun was ever recovered. Mr. Henry was then tried and convicted in Will County. In regards to the incident against Mr. Kosich, Mr. Henry was convicted of attempted aggravated vehicular hijacking, armed robbery regarding Mr. Kosich's cell phone, and the theft of the cell phone. In regards to the incident against Mr. Scott, Mr. Henry was convicted of aggravated vehicular hijacking and theft of Mr. Scott's car. In addition, Mr. Henry was convicted of unlawful possession of a weapon by a felon based on his alleged use of a firearm in the incidents against Mr. Kosich and Mr. Scott. Now, to put my argument in the simplest of terms, Jordan Henry was tried for these offenses in the wrong county. The venue rules in Illinois are governed both by the Illinois Constitution and the venue statute, 720 ILCS 5/1/6, excuse me. Generally speaking, criminal actions are required to be tried in the county where the offense was committed, but various provisions of the venue statute address crimes that the legislature has determined can be committed in more than one county. Subsection G covers the offense of theft and provides that for the purposes of prosecuting theft, venue is proper in any county in which the accused exerted control over the stolen property. Here, the state argues and the trial court agreed that this provision automatically attaches to every crime for which theft is a lesser included offense, including, as relevant here, armed robbery and aggravated vehicular hijacking. But this goes against both the plain language of the venue statute and Illinois Supreme Court precedent. First, subsection G refers only to the offense of theft. There is no language in that subsection that indicates the legislature intended for it to automatically apply to every offense for which theft is a lesser included. Indeed, in the Illinois Supreme Court's decision in People v. Gilliam, it makes clear that theft being a lesser included to robbery is irrelevant in determining whether the proper venue in which to prosecute a robbery lies in more than one county. The question is ultimately whether the robbery continued into more than one county. In Gilliam, the defendant committed an armed robbery in Chicago and locked the victim in the trunk of her car, and then traveled with the victim in her trunk to another county where he was later prosecuted. The defendant argued that the county where he was prosecuted was not the proper venue because the robbery against the victim was completed in Cook County when he took control of the victim's car by force. The Illinois Supreme Court recognized that the robbery was technically completed in Chicago, but found that it continued into the second county because the force against the victim never ceased. Gilliam makes clear that...
Did they say it was technically completed? Or...
The Illinois Supreme Court, yes, did agree that the robbery was completed in the city of Chicago when he took...
But the force is an element of robbery, isn't it?
Yes, and he took control of the car by force in Chicago.
But it was, the offense was ongoing. That was the point, that Justice Holdridge is making it guilty.
Yes, the offense was ongoing because the force against the victim never ceased. It continued into the second county, and that didn't happen
So
here.
would one conclude that the robbery was ongoing?
Yeah, it continued. I would agree with that, yes.
Okay, so the Supreme Court misstated?
No, I'm just, that language, they agreed that the robbery was technically completed in the city of Chicago when completed, but then continued, if that makes sense.
Makes no sense.
It makes no sense?
But it is in the case.
It is in the, yes, so the two elements that comprise robbery, the taking and...
Well, the element is the continued force.
The continued force is what is important, right?
Made it ongoing.
Right.
Yes.
And here, that is not the case. The force against the victim ceased in the city of Chicago. Neither of the victims traveled with Mr. Henry into Will County. Therefore, the robbery did not continue into Will County as it did in Gilliam when the victim was stuffed in the trunk of her car. The force against the victim there continued on into the second county. That didn't happen here. After the use of force ended against both of the victims in the city of Chicago. After their respective encounters with Mr. Henry, they remained in Chicago where they spoke to Chicago police officers, again, about the crimes that happened to them in the city of Chicago.
But the attempted theft and the theft of the second victim, what about that? That hasn't ended.
Against the, yes.
The attempted has, right?
But against the second, you're talking about the second carjacking?
Yes.
Yes. That ceased in the city of Chicago when he took the victim's car and drove off in it. The force against the victim ceased as soon as he took the car and drove off. The force against the victim did not continue into Will County.
So, okay, robbery. You're talking about robbery now.
And the attempted vehicular hijacking. Robbery and vehicular hijacking are essentially the same offenses. Robbery includes the taking of property that is not a vehicle and through the use of
why would they distinguish vehicular hijacking from just generally robbery?
That you would have to ask the legislature that question.
Okay.
They're,
But again,
they're treated the same.
they are absolutely treated the same. And so again, the force used to take the victim's cell phone, to take the second victim's car, all of that ceased in the city of Chicago. None of that continued on into Will County. And again, because neither the armed robbery against Coppedge or the aggravated vehicular hijacking against Mr. Scott continued into Will County was not the proper venue in which to try Mr. Henry for these offenses. And the trial court erred in denying the motion to dismiss. The trial court also erred in denying the motion to dismiss with respect to the unlawful possession of a weapon by a felon charges and the attempt at aggravated vehicular hijacking charges. In regards to the unlawful possession of a weapon, the state presented no evidence that Mr. Henry ever possessed a gun in Will County. No gun was ever recovered from Mr. Henry's person and the vicinity where he was arrested, his belongings, or from the Jetta. And there is absolutely no evidence that Mr. Henry, if he indeed had a gun during the incidents in Chicago, which we do contest, if he indeed had a gun, there's no evidence that he ever brought that gun into Will County.
What about
Sorry.
I think we're going to say the same thing, the circumstantial argument. You're dismissing that completely?
Well, first of all, none of that was presented at the hearing on the motion to dismiss, where the state had the obligation to prove by a preponderance of the evidence that the crime was committed in Will County. Second of all, the circumstantial evidence, the police chose not to look for a gun. If he had indeed dropped a gun, the police could have found it.
Are we limited? We're not limited to the arguments at the motion to dismiss. We can also consider the evidence at trial, correct?
I would argue that because we are challenging the motion, the trial...
The venue argument.
The venue argument, right, where the trial court's denial of the motion to dismiss based on improper venue.
So you're saying we can't consider the testimony that he fiddled with his jacket and...
I would argue no, because the state did not present that at the hearing where they had the burden to prove that this crime was committed in Will County. They didn't do that here.
So this is not a rhetorical question. Are you saying that there's no case law suggesting that is there any case law saying we can't consider the facts of trial as it relates to the venue question on appeal?
First of all, venue doesn't have to be proven.
I'm aware of it.
No, I know.
But you preserved the issue. You raised it pre-trial. You had a trial. You raised it post-trial. Now you're in the appellate court. My question is there any case law about whether we can consider the facts of trial as the propriety of venue? You seem to be suggesting we're limited to the arguments made before trial, and I'm just not certain that's correct.
I'm not aware of any case law, Your Honor, but again, the error here that we're alleging is that the state didn't prove their burden at the hearing on the motion to dismiss.
Yeah, you're actually circumscribing that issue. So you're saying anything subsequent at trial in terms of evidence, which there was.
But
I mean, there was...
The state did not have to prove that the possession was in Will County at the trial. They only had to prove possession, correct? So that could have been the Cook County evidence.
Yes, that is also true. So, and again, also, I think it's important to note that there was an hour in between when Mr. Henry took Mr. Scott's car and when he was spotted by the police, giving him ample time to dispose of a gun if he had one. The evidence, even if you do consider the trial evidence, the evidence is that he was reaching towards his pocket. He could have been pulling up his pants. That is ambiguous at best. And again, if one of the officers testified, I believe it was Officer Whitbeck, testified that if he had seen a suspect dropping something, that would have been investigated. And it wasn't. The officers here chose not to look for a weapon, and the state does not just get to say, well, maybe he had one. They have to prove it. So again, because there was no evidence that Mr. Henry committed the offense of unlawful possession of a weapon by a felon in Will County, the judge erred in denying the motion to dismiss with respect to this charge. Now, the state concedes that Will County was the improper venue to try the attempt aggravated vehicular hijacking charge because no element of that offense was committed in Will County. But the state argues that the denial of the motion to dismiss was harmless error. The error here was not harmless, and by that I mean improper venue is not subject to harmless error analysis, which is reserved for trial errors, i.e. those occurred that during the presentation of the case to the jury. The trial court's denial of counsel's pretrial motion to dismiss for improper venue wasn't an error that occurred during the presentation of the case to the jury. It was not a trial error. It was a pretrial error that affected the structure of Mr. Henry's trial and is therefore akin to structural error. The United States Supreme Court in Weaver v. Massachusetts outlined various rationales that support finding an error is structural, including, as relevant here, the right at issue isn't designed to protect the defendant from erroneous conviction, but instead protect some other interest, and two, the effects of the error are too hard to measure. First, a defendant's right to be prosecuted in the county where he committed the offense is designed in part to protect the defendant against prosecutorial forum shopping. And it also serves to protect the defendant from the unfairness and hardship of being prosecuted in a remote place. So those are both errors that are different from...
Now, who is that from that Massachusetts case you're citing?
Weaver v. Massachusetts, yes.
Yes, okay.
Yes. And then again, the effects of this error are too hard to measure. It's really impossible to know what might have been if Mr. Henry had been tried in Cook County rather than Will County. As one of the officers testified when Mr. Henry was arrested, he told Mr. Henry, "You're in Will County. It's going to be a totally different situation than Cook County." And again, we really don't know the effects of this error. Just to note, Cook County's racial demographics are markedly different from Will County. Cook County has nearly doubled by percentage the amount of Black residents, meaning that a Cook County jury would have been significantly more likely to contain people like Henry who are Black. And Cook County prosecutors also might have offered Mr. Henry a more generous plea deal than what Will County prosecutors were willing to offer. But again, even these are speculative, demonstrating that the precise effects of this error are difficult to ascertain.
And the focus of it doesn't need to be just on the trial? You're saying negotiations can also be part of the structural error argument?
Well, and that's just an example as to why the effects of this error of being tried in the wrong county are a little bit difficult to measure. It's just an example, a demonstrative example of that we don't know what Cook County prosecutors might have. We don't know how things would have played out differently if this case had been tried as it should have been in Cook County.
But other than the fact that you're arguing it should have been tried in a different county, what was different about the trial?
First of all, he chose to do a bench trial, which he may or may not. He may have done, knowing that a Will County jury might have been more conservative, more white, less likely to contain people that looked like him. He may have chosen to do a bench trial because of that. But again, these effects are difficult to ascertain, and that's why this is more akin to structural error and isn't harmless.
So it's structural error as to which offenses?
As to the ones that were tried in the wrong county. So that would be There's 13. Yes, there are 13 offenses. There's 11 offenses. So that would be the aggravated vehicular hijacking against Mr. Scott, the attempt aggravated vehicular hijacking against Mr. Kosich, and then the armed robbery charges.
Okay. Thank you.
As well as the unlawful possession of a weapon by a felon.
Where is this example? It's over there.
Oh, my gosh. Oh, red light.
Oh, okay.
Okay.
Well, you're on.
Do you just want to make a summary conclusion?
Yes. In conclusion, the trial court erred in failing to dismiss the offenses we just talked about. None of these crimes were committed or continued into Will County, and Will County was not the proper venue. And we respectfully request that this court reverse Mr. Henry's conviction for those offenses.
Any further questions from the bench?
No.
Thank you. You got time in reply.
Thank you.
Mr. Trejo?
Yep.
You may respond.
May it please the court, counsel, Adam Trejo on behalf of the people of the state of Illinois. The defendant will first like to address, the state would first like to address defendant's argument that it forfeited its response regarding count 11. Count 11 charged the defendant with the unlawful possession of a weapon by a felon. In the state's brief, it argued that the circumstantial evidence showed that he had a gun that he used to rob Goldman of his phone and also Victoria of his phone and Goldman of his vehicle. Although there was an hour time lapse, the circumstantial evidence showed that after police tried to pull him over, he fled from Cook County to Will County. Police officers testified that they didn't see the defendant throw out anything out of the vehicle, and after he crashed the vehicle in Will County and fled, that police officers testified that they saw him remove his jacket and reach towards his waistband. Defendant argues on appeal that the state forfeited that argument, but that's not true. Although the state didn't emphasize that argument at the hearing, it did raise it in its response to defendant's motion to dismiss, and the state would like to direct the appellate court to Common Law Record 62 through 63, where the state does raise that argument. And again, you don't have to, there's a lot of counts contested, so the emphasis at the hearing was counts 1 through 5, and that's what the state focused its argument on, but it just preserved that argument. The state will now address the defendant's argument in regards to counts 1 through 5, which charged the defendant with various counts of aggravated vehicular hijacking and armed robbery. The crux of defendant's argument really relies on People v. Gilliam to support his contention that structural error occurred in this case, but a review of the case shows that it doesn't support his position at all. As defendant argued in their opening remarks, in that case, aggravated robbery was completed in Cook County. However, the essence of robbery continued into a different county, Jefferson, and the essence of robbery, the Gilliam court stated, was use of force or threat of force. Defendant's interpretation of Gilliam has, defendant's interpretation folded into its argument suggests that in order for the essence of robbery to be continued, the victim has to be attached to the property, as the victim was in Gilliam, but that's not the case. That's not the holding. The essence of robbery must continue, and that's what happened here. After the defendant stole the first victim's cell phone and then robbed Goldman's vehicle, police officers proceeded to stop him in Cook County. And thereafter, he used force, and that's definitely the threat of force, to maintain that property. He continued fleeing Cook County into Will County, putting the lives of other drivers at risk.
Counsel, you're suggesting that aggravated fleeing and looting is a use of force?
Well, I'm focusing on the defendant's conduct. He used the vehicle in a reckless manner, and that supports, in a reckless manner, to flee the police and to evade detection. That's force. I think he reached up to speeds of 150 miles per hour. That is the use of force to maintain that property. So the essence of robbery continues.
So the force is really directed toward the property in your house.
Exactly. It's not necessarily directed to the victim, because these aren't crimes against the specific person, they're crimes against property. And so the analysis is focused on the acts the defendant did regarding the property, not necessarily.
Ultimately, you're focusing on the continued possession of the property, not the speed you're driving the property.
No, the state's focusing on his actions, which constitute use of force to maintain that property.
So if he was driving the speed limit in Will County, you would concede that you didn't have jurisdiction?
No, not necessarily, because he was still depriving.
So it is the continued possession of the vehicle.
That in conjunction with the manner he operated.
Well, I want to change the hypothetical. He's driving the speed limit. He's located in Will County. He pulls over when the MARS lights are activated.
Well,
is he still committing the offense of aggravated vehicular hijacking in Will County?
Yes, because he's continuing to maintain that property and he's not surrendering that property.
Right. So it's the continued possession of the property.
That's not the state's position. It's not, even though the force doesn't have to be extreme. You don't have to cause harm to, you don't have to actually cause harm to another person. It's just
Let me ask you a question. If the facts were nothing other than he's found in possession of the vehicle in Will County, and it becomes clear that he drove straight from Cook to Will when he was observed and stopped,
would he be guilty of aggravated vehicular hijacking in Will County?
Well, the issue isn't if he's guilty, again, at
Would venue
at a
be
motion,
proper, would venue be proper in Will County?
exactly, because,
It's a yes or no question.
yes, because, the standard of review at a motion to dismiss regarding venue is a preponderance of the evidence. It's not beyond a reasonable doubt. But the state would like to emphasize that, the trial court relied on Angerman for its decision to, deny defendant's motion to dismiss. And the defendant on appeal attacks Eggerman, although since 1997, there's been no case disagreeing with it. The manner in which the defendant attacked Eggerman on appeal, they're arguing that the court in Eggerman improperly used an analysis. And the analysis stems from the following proposition, that venue is proper in any county where an element of the offense occurred. And Gilliam and Angerman are very similar in that they apply the same analysis. Gilliam didn't explicitly state so, but they're focusing on whether one element was committed outside a different county. It's essentially the same analysis. However, the difference is which offense the court applied that analysis. In Gilliam, the court applied the analysis to the charged offense. In Angerman, the court applied the analysis to a lesser included offense, and that is theft. And because the defendant possessed the stolen item in that county, venue was proper. And no court has disagreed with that analysis or reasoning. Pursuant to the doctrine of stare decisis, Angerman controls. It's still good law. Theft was a lesser included offense of aggravated vehicular hijacking and robbery, which the defendant doesn't contest. And as long as the defendant exerted control over that property in Will County, venue was proper pursuant to Eggerman. The state would like to move on because it does concede counts 6 and 7 that venue was improper regarding attempt vehicular hijacking in regards to the first victim, Tory Coach. Defendant argues that structural error is the appropriate analysis, and the state disagrees. Defendant doesn't cite any case standing for the proposition that error in not granting a motion to dismiss based on venue is structural error. The state actually cites a case, People v. Holmes, where the reviewing court applied a harmless error analysis in regards to the defendant arguing that the venue was not dismissed. So harmless error does apply in this case, and the state cites People v. Holmes for that proposition, which the court did apply it. And the analysis regarding harmless error, the statements prove beyond a reasonable doubt that the jury verdict would have been the same absent the error, and the state posits that it is because the evidence was overwhelming. He's not contesting on appeal identity. He's not contesting that he wasn't found in Will County fleeing after crashing the second victim's vehicle. This is totally within the realm of harmless error, and it is absolutely harmless. Does this court have any other questions?
Just to follow up on your last statement there, would that also apply to the circumstantial evidence that was used on the possession, unlawful possession charge?
Yes, absolutely. Venue can be proven by circumstantial and direct evidence, and of course...
No, the structural error argument, because that was a much closer call. I think you could see that.
In regards to which count?
The unlawful possession of a weapon by a felon.
Count 11?
I don't know.
Okay, yeah, count 11, yes, the circumstantial evidence would apply to that count. Barring any further questions, the people of the state of Illinois respectfully request that this court affirm defendant's convictions.
Any questions? No. Okay, thank you, counsel.
Okay, thank you.
Counsel, you may reply.
So in regards to counsel's argument that the driving erratically constituted the continuation of force, that just doesn't track with how robbery is conceived of. Robbery requires taking from the person or presence of another through the use of force or threat of force. That implies that the force has to continue against the victim. And again, that is what Gilliam makes clear, is that the force has to continue against the victim. The court emphasized in Gilliam that it was the defendant traveling with the victim locked in the trunk of her car. So again, the force continuing against the victim is what allowed them to conclude that the robbery had continued into Jefferson County. And that just is not the case here. The force against both victims ceased in the city of Chicago and did not continue at all into Will County.
Counsel? Go ahead. Eggerman.
Yes.
How do you get around it?
How do I get around it? Eggerman, the portion discussing the venue argument, it was wrong. Plain and simple, it was wrongly decided. They conflated and confused the venue rules and the rules for double jeopardy. And it relied upon a premise that they stated was, generally speaking, it was a general premise that venue is proper in any county in which any element of the offense is committed. But if you trace back the case law that they cited for that proposition, it traces back to a case that cites subsection M of the venue statute, which is applies only to inchoate offenses. And it's clear that this is not a general proposition, right? Because if it applied to all offenses, then there would be no reason for it to be specifically enumerated in the venue statute for inchoate offenses. It would automatically apply.
So your position is if the woman was not in the trunk of the car in Gilliam, that decision would have come out differently?
Correct. Correct.
What about the theft being a lesser included? How is that?
Theft being a lesser included is irrelevant for the purposes of determining the proper venue.
For the robbery?
Yes, for the robbery. Again, the statute makes no mention of the theft provision applying to any offense for which theft is a lesser included.
But there is a theft provision.
There is a theft provision. Yes, we're not contesting that. It is in the statute. We can't contest it. But it does, again, theft being a lesser included of armed robbery, vehicular hijacking is irrelevant when it comes to determining the proper venue for those offenses. For those offenses, again, here, those offenses were committed entirely in the city of Chicago. They began in Chicago. They ended in Chicago. They did not continue into Will County, and therefore Will County was the improper venue in which to try those offenses.
Can you address or recap for us your position on harmless error?
On harmless error? Yes. This is not a trial error. It's one that affected the structure of the trial. It affected, again, the judge that Mr. Henry was seen in front of. It affected what counsel he had. And this is more akin to structural error because, again, here, the effects of this error are a little difficult to measure. As I stated, we don't know what could have been. We don't know for sure. The state says, oh, he would have been convicted in Cook County. We don't know that. That is pure speculation. We don't know what Cook County prosecutors, what kind of plea deal they would have been willing to offer, which could have affected what offenses he ultimately was convicted of and sentenced for. We don't know the effects, and that, again, makes it more akin to structural error and not harmless error. And if your honors have any more questions, I'd be happy to answer, but if not.
No questions.
There was one case study about the state Smallwood.
Yes.
And you address the analogy that they made between a sentencing enhancement using kind of the same arguments.
I would argue, and I argued in my reply that Smallwood is actually not in opposite to our position here. In both Smallwood and in Gilliam, the force against the victim continued, and here it didn't. It's that simple. Our position is that simple.
Further questions? No further questions from the bench. Thank you.
Thank you.
Thank you, counsel, both for your arguments in this matter this afternoon. It will be taken under advisement, this case, and a written disposition shall issue in due course. And at this time, since this is our last case here, the court is concluded for today. Okay? And we stand adjourned.
Ladies and gentlemen, court stands in recess. As stated.
Adjourned.